Good morning. This is March 11th, 2020, and my name is Nancy DePel. I'm the regulatory law judge assigned to this hearing. This is case number ER-2019-0335 in the matter of Union Electric Company doing business as Ameren, Missouri's tariffs to decrease its revenues for electric service. We've come here today for the evidentiary hearing, and all of the issues have stipulation and agreements, except for the one fuel adjustment clause issue, so that's what we're going to hear today. We're going to begin with entries of appearance, and I'd like to begin with the company.
Good morning, Your Honor. Jim Lowry, Smith Lewis LLP, P.O. Box 918, Columbia, Missouri, 65205, appearing on behalf of Ameren, Missouri.
Wendy Tatro, 1901 Choteau Avenue, St. Louis, Missouri, 63103.
And commission staff.
Karen Bretz for staff. The court reporter has my information.
All right. Office of the Public Counsel.
Good morning, Judge. Caleb Hall appearing on behalf of the Office of Public Counsel. I previously supplied my contact information to the court reporter.
Okay, and the other parties who did not have testimony specific to this issue asked to be excused, and I have done so with my usual caveat that they waive any right to make any objections or enter any additional evidence on this issue. So because one of the issues we had planned to have today live, we did not enter testimony from that issue at the presentation last Wednesday, so I'd like to go ahead and do that. Can we begin with Ameren?
Yes, Your Honor. We have, I believe, 7 pieces of testimony to enter on those other issues, starting with Exhibit 5, rebuttal testimony of Ben Hassey. Then Exhibit 11, direct testimony of Laura Moore. Exhibit 12, rebuttal testimony of Laura Moore. Exhibit 13, surrebuttal testimony of Laura Moore. Then Exhibit 14, direct testimony of John Reed. 15, rebuttal testimony of John Reed. And 16, surrebuttal testimony of John Reed. And that should be all of our pre-filed testimony except for witnesses appearing today.
Okay, thank you. Would there be any objection to those exhibits coming into the record?
None.
Seeing none, then I will admit Exhibit 5, Exhibit 11, 12, 13, 14, 15, and 16. And then staff, you had additional testimony?
Yes, Judge, we have 2 exhibits. We have what's been marked as Exhibit 120, which is the rebuttal testimony of Mark Oligschlager, and then also Exhibit 127, which is the surrebuttal testimony of Mark Oligschlager.
Okay, would there be any objection to those exhibits? Seeing none, I will admit Exhibits 120 and 127. And Public Counsel?
Yes, Judge. Given the reconciliation of the affiliate transaction issue, we have 3 exhibits for admission. The direct rebuttal and surrebuttal testimony of Robert Schallenberg. Those numbers are 206, 207, and 208, respectively. And at this time, I move for their admission.
And 207 and 208 both have confidential versions,
207 has a public and a confidential version. That is correct.
But not 208, just 207?
208 is, I missed that. 208 has a public and confidential version as well.
Okay. Would there be any objection to Exhibits 206, 207, and 208?
No objection.
None.
Seeing none, I will admit those exhibits. Okay, and then yesterday, Ameren filed a motion to take official notice of multiple items. I'm Would there be any objection, just in general, to those items? And then if there are, I'll get into the specifics.
We don't have any, Judge.
All right, if there are no objections to the commission taking official notice of the items, I'll just read them so that it's clear in the record. Staff's fuel adjustment clause prudence review reports for Ameren, Missouri in file numbers EO-2010-0255, EO-2012-0074, EO-2013-0407, EO-2015-0060, EO-2016-0228, EO-2018-0067, EO-2019-0257, the Commission's report and orders in file numbers EO-2010-0255 and EO-2012-0074, and the Commission's orders approving staff's prudence reviews in file numbers EO-2013-0407, EO-2015-0060, EO-2016-0228, EO-2018-0067, and EO-2019-0257. Then the fuel adjustment clause section of Commission reports and orders in the following Ameren, Missouri electric rate cases, which were ER-2008-0318, pages 57 to 76, ER-2010-0036, pages 72 to 80, ER-2011-0028, pages 74 to 92, ER-2012-0166, pages 73 to 93, ER-2014-0258, and also official notice of Commission Rule 20 CSR 4240-20-090. And last but not least, the fact that there have been 32 adjustments to rates charged under Ameren, Missouri's rider FAC since it first became effective starting in March 1st of 2009. And that the Commission will take official notice of those items.
Your Honor, I think this is clear enough from the record based on the case law under 5360705, since we are offering those documents you referenced by reference. I think we are actually supposed to offer them, and in addition to taking notice of them, I think the statute contemplates that we offer them. So I formally offer those documents as well by reference.
And with, once again, just so that it's clear, then would there be any objection to those items coming into the record?
No.
Seeing none, then those are admitted by official notice by reference. Okay, so Mr. Lowry also noted that the testimony of Mr. Byrne on this issue got left off of the official witness list or the proposed witness list that you all had filed. Does Ameren intend for Mr. Byrne to go first or second?
We intended him to go after Mr. Meyer, so second.
Okay. Then with that, I think we can begin opening statements. And the first opening statement is Ameren, Missouri.
Good morning, Commissioners, Judge. So every single issue in this case has been resolved by all of the parties with one exception, and that issue is the sharing percentage to be used in the company's fuel adjustment clause, or FAC. All of the parties agree that Ameren, Missouri should continue to have an FAC. All of the parties agree that the cost, which cost should flow through the FAC, and OPC only takes issue with the sharing percentage in this case. So let's start with some FAC history. Ameren Missouri's FAC was first put into place in 2009, and consistent with the Aquila FAC that had been approved before it, the tariff included a 95.5 sharing percentage. That is, any net costs above or below the amount included in base rates would be shared, 95% to customers and 5% to Ameren Missouri. Now, the reasoning behind the 95.5 sharing was that the commission wanted utilities to have some additional incentive to manage their FAC costs while also remaining faithful to the overall purpose of the FAC, which is to allow utilities to recover their prudently incurred FAC costs. Since 2009, all electric utilities in Missouri with an FAC have had that 95.5 sharing percentage. Not that the commission hasn't been asked or that there haven't been efforts to change the sharing percentage. There have been. In fact, if you look at the rebuttal testimony of Andrew Meyer in this case, specifically Exhibit AMM-R1, from which the information on this document, which is kind of small up there, and maybe I should have printed it nice and large like I did for the on the record. But that lists every rate case since I think Ameren Missouri's 2007 rate case, where there was discussion about sharing percentages of the FAC. If you were to count them, there are 18 cases in which individuals challenged the FAC sharing percentage. Not 5, not 10, but 18. And of those 18 cases, Lena Mantle was the witness that requests the change in 9 of them, and those are the cases that are highlighted in yellow. That's the number of times she's requested, with this case being number 10. Now, despite the multiple requests, Ms. Mantle's recommendations to change the sharing percentage have not been adopted in a single case. In fact, in every case where any party recommended a different sharing percentage, and that's the 18 listed up there, the commission retained the 95.5 sharing. As Mr. Byrne testifies, there is benefit in regulatory stability and in the commission not changing the sharing percentage in each and every case, despite having been asked to do so multiple times. Otherwise, the sharing percentage becomes up for grabs in every rate case. It will result in different sharing percentages for different utilities and will represent regulatory inconsistency at its worst. That is, inconsistency without a reason. This mechanism was not supposed to produce winners or losers. It was supposed to allow for recovery of prudently incurred costs over which the utility has little control. So what is the basis for Ms. Mantle's recommendation? Her testimony relies on a few arguments: vague warnings of FAC abuses, an argument that Ameren Missouri could earn more under increased sharing, and a reliance upon a new capital investment statute. So let's discuss those. First, Ms. Mantle's dire warning. She makes a truly ridiculous and frankly offensive argument that Ameren Missouri in this case gamed the FAC by intentionally setting the MBEC in the case too low in order to gain a PR benefit from filing for a rate decrease. She went on in her testimony to assert that Ameren Missouri is willing to suffer any loss created by the 5% sharing, again, for some PR benefit. Commissioners, this is patently untrue. If you ask Ms. Mantle if she has any direct evidence that Ameren Missouri manipulated its NBEC calculation in this case in order to obtain a rate decrease, she will answer she does not. That is because there is no such evidence to support this ridiculous claim. The only evidence, and even this is indirect, is that she believes the off-system sales revenue level used in the production cost model was too high. And even if she's right, that doesn't prove manipulation. It only proves we have a difference of opinion on an input disagreement, nothing more. And again, if you were asked Ms. Mantle where a disagreement on an input is proof of deliberate manipulation, she will admit it is not. And you don't have to take my word for it. Staff proposes an even higher level of off-system sale revenue in their modeling. Staff's NBEC indirect is lower than Ameren Missouri's, and staff's true-up NBEC is even lower than that. Staff's overall revenue requirement is lower than Ameren Missouri's original ask. So if Ameren Missouri was manipulating the calculations, Staff's NBEC calculation would have been higher, and its revenue requirement would have been higher, but it was not. It was lower. So does OPC and Ms. Mantle really believe that staff is in on some conspiracy with Ameren Missouri to force the revenue requirement, in this case negative? So how strongly does OPC believe this manipulation argument? OPC signed the stipulation and agreement in this case, reserving only 2 issues, one of which has subsequently been resolved. The NBEC set forth in the stipulation uses staff's true-up NBEC. So OPC agreed to use the lowest NBEC in this case. Surely OPC would not have agreed to that if it believed it was the result of manipulation on the part of the company or on staff. Again, it's an inflammatory insertion without any direct evidence, and you should pay it no mind. Now, it is true that the cost decrease in Ameren Missouri's NBEC are offsetting O&M increases elsewhere. That's not proof of manipulation. Instead, it's a demonstration of the effort that Andrew Meyer and his team put into properly managing fuel costs. If anything, this proves the current sharing percentage works, not that it does not. And the company did not hide this fact from its customers. I would point you to the notice that was provided to all Ameren Missouri customers, a notice that was written by Ameren Missouri and was approved by this commission. The notice explicitly stated, the overall reduction in base rates proposed by Ameren Missouri in this case is associated with the rebasing of these net energy costs. In this case, the reduction in costs due to the rebase of net energy costs is largely offset by net increases in other costs. If the net energy cost had not been rebased in this case, the base rates proposed by Ameren Missouri in this case would have increased the typical residential customer bill by 3.7%, end quote. And there's more evidence that disproves Ms. Mantle's allegations. As Mr. Meyer points out, Ameren Missouri has undergone 7 prudence reviews since 2009. Now, 2 reviews involved a dispute about a classification of a contract, but even that was not used to justify an increase in the sharing percentage, as the Commission explicitly found in a July report and order in ER-2019-0028. And through all of these prudence reviews, Commissioners, the undeniable fact is that no party has argued the company imprudently managed its FAC costs or revenues. No one says Ameren Missouri doesn't negotiate hard enough. No one says it overpaid for coal. Nothing like that has been raised. And accordingly, the Commission has never held that Ameren Missouri acted imprudently in regard to its FAC at all. Next, Ms. Mantle argues that a larger sharing percentage could allow Ameren Missouri to keep more money if actual costs are lower than the base amounts, because we'd be keeping 15% instead of 5%. I submit to you that this argument flies in the face of the purpose of the FAC. The FAC should not be a vehicle for a utility to make money or to lose money. It ought to be a mechanism to allow management of large and volatile costs and revenues over which the company has little control. Ameren Missouri, frankly, doesn't believe any sharing mechanism is necessary. Virtually every utility across the country has an FAC, and only a few of them have any sharing at all. But the company has accepted and continues to accept this Commission's longstanding view that a 5% sharing mechanism is warranted. And Commissioners, as you know, if the company were to mismanage its NBEC cost and revenues, the Commission would disallow imprudent expenditures, and in severe cases, the company could lose the FAC mechanism in total. These are powerful incentives, in the company's opinion, before we ever even get to the sharing percentage. Now, Ms. Mantle's newest argument is that Senate Bill 564 set a sharing percentage of 85-15, and that 85-15 percentage should be used for all utility incentive mechanisms. Again, there is no basis for her claim. Senate Bill 564 does set a sharing percentage for plant and service accounting, or PISA, but it didn't amend the FEC statute, and it didn't attempt to amend the FEC statute. And as Ms. Mantle's surrebuttal testimony makes very clear, the PISA statute and the FAC statute deal with very different aspects of utility costs. Let me read you what she said on pages 4 and 5 of her surrebuttal. As Ameren Missouri witnesses Byrne and Meyer testified in their rebuttal testimony, PISA applies to capital expenditures and the FAC applies to expenses. I, Ms. Mantle, would take that one step further by saying that PISA expenditures are completely under Ameren Missouri's control. It can decide the timing and the amount of the expenditures. Ameren Missouri has less control over its FAC costs. The FAC costs are largely dependent upon the Mid-Continent Independent System Operators, or MISO, markets, fuel prices, and load demands of customers, end quote. Now, Commissioners, I can't speak for why legislators adopted the 85-15 sharing requirement, but the law sets the sharing percentage, but only for capital investments once a company has elected to adopt PISA. Now, Ameren might take issue with Ms. Mantle's idea that the company doesn't have at least some required capital investments, but certainly we have far more control over PISA investments than we do FAC costs. I submit to you that flips Ms. Mantle's arguments on its head. A greater incentive might be required when an investment is discretionary than when the spending is over which the utility has little control. In other words, her own argument demonstrates that a greater sharing percentage for PISA makes more sense than a greater sharing percentage for the FAC. Ms. Mantle will also argue that the higher sharing percentage, the better Ameren Missouri will manage its fuel costs and revenues. But nowhere does she tell you how. She offers no evidence of what might happen. None. Her increased incentive argument is theoretical, not based on fact, and should be rejected. Now, finally, Commissioners, you should recognize there are real dollars involved in this argument. As stated in Mr. Meyer's rebuttal testimony, since 2009, the 5% sharing mechanism has equated to $42 million in actual, prudently incurred costs which have not been recovered by the utility. That means a 15% sharing would have resulted in $126 million in unrecovered, prudently incurred costs. Now, perhaps Ms. Mantle does not consider those numbers significant, but my management certainly does. A change in the FAC sharing percentage is not needed. Ameren Missouri manages these costs and revenues appropriately, and all such requests have been rejected by this commission over and over and over. The fact is, we're here again today to hear the same arguments as before. Your ruling should be the same as it was before. There's no reason to change the sharing percentage in the previous 18 cases where an attempt to do so was made, and there is no reason to do so today. Thank you for your time.
Thank you. Commissioners, did you have any questions for Ms. Tatro at this time? Okay, thank
Do
you.
you have printouts if someone wanted to see this? I know it's not very legible up there. Thank you.
All right, Ms. Tatro, could I get you to, before you sit down, could I get you to come over here and find
Asking me to
the,
do check stuff, okay.
I am, find the escape key on the keyboard, and I think that that will take your presentation down. Or you can just close it there.
No pressure.
There we go. That's fine. No, whoop.
I warned you.
We can bring
You
that
can pull it back up.
Okay, okay. That's fine. Okay, commission staff.
Good morning. May it please the Commission. My name is Karen Bretz, representing staff. The Fuel Adjustment Clause, commonly known as the FAC, is designed to address fuel and purchase power cost volatility as well as off-system sales.
Let me ask you to
Get closer in? Okay. I'll raise it up a little bit. I'm a little taller than Ms. Tatro. The Commission has traditionally applied a sharing mechanism that allows the utility and its ratepayers to share in over and under collections. If actual incurred fuel and purchase power costs are less than estimated, 95% of the savings is returned to customers and the utility keeps the other 5%. At the same time, if actual incurred costs are more than estimated, the utility receives more timely recovery of 95% of the difference. The Commission has stated that this sharing mechanism gives the utilities an incentive to economize and allows ratepayers to share in any savings. Staff and Ameren support maintaining this 95-5 sharing. OPC advocates for changing the mechanism to 85-15. OPC advocates for this because OPC believes that Ameren is trying to game the FAC for PR purposes. OPC believes that while Ameren has stated that this is a rate decrease, it's actually a rate increase. According to OPC, Ameren proposes artificially low normalized fuel and purchase power cost in this case to keep base rates down. OPC believes that Ameren will make up for this difference with higher FAC costs down the road, and that the 95-5 sharing mechanism is not enough incentive for Ameren to front-end more normalized fuel and purchase power costs. So where does OPC come up with this 85-15 proposal? OPC uses an analogy. It analogizes the FAC statute to the Plant in Service Accounting, commonly known as PISA statute. The PISA statute allows a utility to recover 85% of total depreciation expenses and return associated with eligible plant additions in subsequent rate cases. While the FAC does not specify the sharing mechanism, the PISA statute is a statutory 85% requirement. PISA is a significantly different type of regulatory mechanism from the FAC in that PISA is a one-way street. Ratepayers always pay for PISA up to the statutory rate caps, and there is no refund mechanism. So where are the similarities between the FAC and PISA statutes? Ms. Mantle states that the similarity is that both statutes create incentives to protect ratepayers' interests. That's it. The differences in these two statutes overshadow the similarities. Please keep in mind we're talking about two different types of costs. PISA applies to capital cost, while the FAC applies to purchase power costs. FAC can either be a ratepayer expense or a refund. PISA is always an expense, and it's a guaranteed recovery. OPC's analogy is not an apples to apples analogy. It's actually apples to pineapples. Also attached to Mr. Meyer's rebuttal testimony is a list of cases in which the Commission has ordered the 95-5 sharing mechanism in the face of proposals from varying parties, just not OPC, to split it in other ways. My point is that the 95-5 sharing mechanism has withstood challenges from numerous parties. Further, all parties have had an opportunity to review Ameren's fuel and purchase powered costs and the modeling. As it is, OPC has no proposed changes. We recommend that you continue to order the 95-5 sharing mechanism. Thank you, and we will tender staff member Lisa Wildhaber to answer any questions that you may have later.
Any questions for Ms. Bretz at this time?
Thank you.
Thank you, Ms. Bretz. And I apologize, Mr. Kaufman, I should have let you make your entry of appearance. Would you like to do so at this time?
Thank you, Your Honor. John Kaufman, appearing on behalf of the Consumers Council of Missouri, 871 Tuxedo Boulevard, St. Louis, Missouri, 63119.
And did you have an opening statement this morning?
I do.
All right.
Would you like for that?
You're up then.
Right. May it please the Commission. I'm representing the Consumers Council of Missouri, and 30 years ago, it was the Utility Consumers Council of Missouri under a different name. And at that time, or rather in the 1970s, that's when the history of the fuel adjustment clause began. So I'm going back a little bit further back. So, you know, from the beginning of Union Electric Company and its certificate until about the mid-1970s, there was no fuel adjustment clause. Fuel costs were estimated, and the utility bore the risk. You know, as you know, they have some control over cost, and the profit, which was definitely a double-digit return on equity at that time, was considered sufficient incentive compensation for the utility to manage the fuel costs. Obviously, they have some control over fuel costs, maybe not a lot, or they say it's a little bit of control, but it's some. Contrast that with utility customers. Utility customers have zero control over these fuel costs. And so, it didn't seem appropriate that there should be some special insurance policy for the utility until about the mid-1970s. Fuel costs were becoming more volatile and were high at that time. The Utility Consumers Council of Missouri thought that was unfair. Piecemealing out the single issue mechanism didn't seem quite fair. The consumers had to bear the volatility for this when they had no control over it. That issue was taken all the way to the Missouri Supreme Court in the famous UCCM 1 case. You may have heard about that. That's really the guiding star of us consumer advocates in Missouri. It struck down the fuel adjustment clause as being unfair, although they did note that the legislature had the ability to, if they wanted to write it in. But the current law would said that the Public Service Commission needs to look at all relevant factors, and so you shouldn't be breaking out and unraveling the rate case process. So we went from the utility bearing 100% of the risk to consumers bearing 100% of the risk for a couple of years, to back the utility bearing 100% of the risk. And that was from 1979 till about 2009. So for about 30 years, we went back to the old way of doing things, where the utility had to bear 100% of the risk. And then during that time, it was interesting. Ameren took the tack that they were actually kind of proud of it. They said that it forces us to sharpen our pencils. And they said, our fuel costs, they were saying, were better than other utilities because they had to really focus on that cost because they had a lot at stake in it. Well, the legislature in 2005 adopted a statute for the fuel adjustment clause, and that's where the story, I guess, begins, as you've been telling it before. It's very clear from the statute that the commission is supposed to revisit this, that the commission has the ability to adopt, reject, or modify in every case. And so it's, I think, entirely appropriate that we talk about it. That statute, as you know, also says that the commission should consider incentives. And in that first case, in 2008, 2009, we had a variety of different proposals. There was significant testimony about how a 50-50 sharing would be an appropriate way to do this. Some parties said 85, 15, and so forth. No party proposed anything as lopsided as 95-5%. As I recall the agenda meeting at that time, all the commissioners were looking at a significant balanced sharing mechanism. One commissioner held out, didn't want any sharing. That was Commissioner Murray, former state representative Connie Weibel Murray, and there was sort of a negotiation at the commission, and they settled on 95-5. She was willing to agree to at least 5%. So at that time, the understanding was that we were going to see how that worked and continue to revisit the issue, and it has. But for some reason, that particular 95% lug that the consumers have to bear has continued case after case after case, but it isn't fair. The utility has some control, consumers have none. Utility already has a very generous return on equity to manage its costs, and the standard shouldn't be prudence. The standard should be, is this what is going to really get the attention of the utility? And I think it's important, I think it's misleading to describe this as some sort of a disallowance. It's not a disallowance. It is symmetrical. Costs go up and down. The question is, how much of an insurance policy should consumers have to bear for something that they have no control over? I say that that the sharing should at least be 15%. From a consumer perspective, this is extremely lopsided, and we're not convinced that it has gotten Ameren to focus on these costs. That the most elegant and the best consumer protections are those that are built in and are not based on prudence. We have almost no confidence in the prudence process anymore. The evidentiary burden has been placed so high, I'm not even aware of any prudence that has actually succeeded in this case. And that doesn't mean we don't have it. Look, my client can't afford a fuel modeling system, did not have the resources to actually launch a prudence investigation. But we rest a little easier at night knowing that the utility has some skin in the game. So the question to you is 95-5 fair, or can we balance this a little bit better? That's all I have.
Thank you. Are there any questions for Mr. Kaufman?
No, thank you, Mr. Kaufman.
Thank you.
Thank you, Mr. Kaufman. Office of Public Counsel?
Let's just get this set up.
I thought Ms. Ticker erased that.
I tried, but I don't have.
He didn't bleach clean it hard enough. May it please the commission. At the outset, I feel the need to depart from my semi-scripted notes and presentations on this point because I find it hard to sit there quietly and have accusations thrown at my office that aren't true. I encourage you to reread the testimony of Ms. Mantle. Nowhere in her testimony does she allege that Ameren engaged in any manipulation or that staff engaged in any manipulation. If someone's feelings were hurt or if there were accusations on this point, I wish that had been discussed with our office prior. What Ms. Mantle's testimony spoke to was how the FAC can operate and what impacts that can have for customers regardless of the utility. Returning to the issue at hand, the final dispute in this case is how much of a sharing mechanism should exist within the FAC. Restated, how much of an incentive should the company have to reduce fuel costs and its utility operations going forward? We've all talked, most of the attorneys here have talked about history. Let's go back to the bygone era of 2005, before we had an FAC. So here, this block that I've put up on the screen is a representation of fuel costs that are put into rates. This is the NBEC number, or net base energy cost number, that we discussed last week. This number includes projections of off-system sales and includes the cost to procure fuel, cost of operation, transmission. There's a multitude of other factors that I'm grossly overstating, but regardless, in this matrix here, this is what we've decided to go in rates, and then that is what is paid for prospectively going forward. However, estimates don't often reflect reality in the future. Oftentimes the situation looks like this, with this black box here. This I'm calling a deficit. This represents a scenario where costs have increased from what they were projected in the rate case. Without the FAC, the company would have to eat that until they come in for its next rate case. This is the boogeyman that is referred to as regulatory lag. On the other side, though, this is the incentive. This is what incentivizes the company to keep costs low, and if costs go below what were set in the rate case, that is a boon to the company going forward. But then come 2006, we don't have this anymore. We have an FAC. What happens in an FAC? This yellow block is a representation of what customers foot. This is the example of when costs are higher from what they were projected to be in the past, for whatever reason. Possibly cost of fuel went up, transmission costs, any other multitude of factors. The customers are paying for 95% of the differential. The company's skin in the game is 5%. Not 5% of total fuel costs, but less than 1% of total fuel costs. We're only dealing with 5% of the differential. With this FAC system, the utility is still recovering over 99% of all fuel costs, of course, those that are prudently incurred. This is what we're talking about right now. This 5 or less than 1% incentive. Where did this incentive come from? This is the language of the authorizing FAC statute. Note that it doesn't say anything about a sharing mechanism. It doesn't prescribe any specific number. It simply advises that the commission has discretion to include an incentive to improve efficiency and cost effectiveness when it approves any fuel adjustment clause. Your predecessors decided on a ratio of 95-5. They recognized that you had to include some type of efficiency incentive. Otherwise, there would be the company would pursue to recover all of the excess costs and argue that they're all prudent. With some skin in the game, you're still having some encouragement to reduce costs. The issue that we're debating now is that enough? When 95.5 was selected, and it has been reaffirmed since 2007, the market has changed, technology has improved, and utilities have improved. We should recognize that and reconsider this issue. I have reprinted one of the blocks from the prior slides, again showing the hypothetical of where costs increase and you have a utility with an FAC with a 95.5 sharing. Let's look at the opposite example again. So this clear box I'm representing, that's the deficit when costs decrease from what they were expected in the rate case. Without an FAC, this is regulatory lag to the benefit of the utility. They get to keep that until the fuel costs are recalculated in the next rate case. With the fuel adjustment clause with a 95.5 sharing, customers are getting 95% of that gain. The utility is getting 5%. Again, 5% of the differential, which is less than 1%. Just last week, Commissioner Roop took umbrage with whether a 1% price variation in a time of use rate would be enough of a price signal to induce changing customer behavior. If this commission is cognizant that 1% may not be enough for time of use, we are simply asking for you to consider and apply that same logic here in the fuel cost regime. If the company's only getting 1% of its gains, why would it necessarily want to achieve those gains? And this is not an accusation towards Ameren. This is just saying, look at the situation here. Consider the issue of self-dispatch or self-commitments that were brought in this case. Sierra Club alleged certain self-commitment and self-dispatch practices on Ameren, or accused Ameren of certain self-dispatch and self-commit activities. We aren't raising those accusations today. But in this scenario, why wouldn't a utility self-commit? If costs increase due to self-commit decisions, costs increase, and then they recover 95% of that increase. Now you might be saying to yourself, well, they wouldn't do that because that gets caught on the back end with a prudence review. Again, FAC only counts for prudent incurred costs, and the self-dispatch as alleged by Sierra Club, they're alleging imprudence, so that wouldn't work in the FAC. Except there's the practical real issue of accounting for that in a prudence review. When Commissioner Holzman asked for specific data to be included and presented to the FAC that was included in the stipulation agreement that addressed the self-commit issues, the answer from the company was that that data was too voluminous to even put into your filing system. An FAC review is 6 months long, and it addresses a multitude of issues that are all put into the FAC, not just self-commit. I struggle to see how an adequate prudence review of that one issue can be done when everything else is considered. I'd also invite you to read the testimony of staff's own witness, Sean Laney, when discussing the self-commit issue. He remarked that due to the highly confidential nature of utilities market bidding strategies, it is highly unlikely that any party other than SPP or MISO have the raw data, modeling software access, and resources to conduct such an extensive analysis of market trends. Your staff is put in the real problem scenario of they admit that they do not have all data available to do a full, complete prudence review of this one issue in a prudence case. In that situation, there is an inherent problem with this framework. The utility will have more incentive to engage in behavior where costs increase versus a situation where they get 1% of the gains from reducing costs. Now, how does OPC's proposal address that? Again, here's a reprint of the current scenario and the hypothetical where a utility like Ameren does the good thing and reduce costs. Here is a representation of our proposal. We are proposing tripling the efficiency incentive. The utility gets 15% of the gains and the customers only get 85% of the gains. This is one of those rare instances in government where you can have a win-win-win. The utility is still recovering almost 99% of all fuel costs through this FAC, through our FAC mechanism. Customers are still insulated from the majority, they are still receiving the vast majority of the gains from fuel cost decreases, and those two results come from the fact that you have tripled the utilities incentive to do better. This is not a punishment. This is a balancing mechanism that is a good thing. So why 8515? Yes, Ms. Mantle turned to recently passed legislation. SB 564, passed in 2018, included the Plants and Service Accounting Provision, or PISA. PISA had a sharing mechanism for, what's the best way to describe this? What was the conceit of PISA? The promises that were made down the street were that incentives were needed to encourage utilities to engage in more capital investment in the state. But again, there was concern that if you just wholly incentivize to engage in capital expense, that they'll just run wild with money and engage in so much more cost, and it'll cause a rate shock. So a balancing was necessary. The legislature, that is representatives duly elected by the people, picked 85%. They saw 15% is the adequate skin in the game for the utility to still be incentivized to engage in capital cost investment while also insulating customers somewhat. Now, there's been claimed that this is a mismatch, that FAC can't be compared to PISA because one's capital costs and one's fuel costs. The idea is that capital costs can be controlled, but fuel costs can't. I mean, I think this is news to a lot of people trading the markets right now. Capital costs can increase due to international markets. We've seen this with tariffs. Steel prices have gone up, and fuel costs are not wholly in control of the utility, but the utility does have control. They enter into short-term and long-term contracts. There's hedging. Ameren has an entire group devoted toward the procurement of uranium, oil, natural gas, and coal. Frankly, if you go with our proposal, Ameren would make money. Since Ameren's last rate case to now, Ameren has given more money back to customers through the FAC than what they have given money back to customers through the FAC. If we had gone with the 8515 in Ameren's last rate case, Ameren would make more money. That is what they're objecting to. The only reason why you would have to disagree with that is that you'd have to say that Ameren didn't have any control of its fuel costs. I think that's a disservice to the profession of the people Ameren's employing. Why does Ameren Missouri employ Andrew Meyer to be in charge of this fuel group if they have no control of their fuel costs? Why not just have a single person who's pushing a button that is randomly self-committing plants if there's no control? There is control. And we're not asking you to punish the company. We're asking you to increase the incentive for them to exercise that control and to be better. If you have any more questions on this point, I can attempt to provide a coherent response. However, I invite you to ask questions of our witness, Ms. Mantle. She has nearly 4 decades of experience in the utility sector, working on both staff and public counsel. She has been working with the FAC since its inception, and she's our office's chief engineer. Otherwise, in closing, I believe I have to formally ask that this be, I'm not admitting it for any, I'm only asking that it be in the record for demonstrative purposes.
I can mark that as a demonstrative exhibit, and I will just for the record, mark it as Exhibit 215 as a demonstrative exhibit. And that is Public Counsel's PowerPoint from their opening statement. Are there any questions for Mr. Hall?
I have one brief question, and I would ask Ms. Mantle, but she hasn't been involved in all these cases. But going back to 2008, OPC has recommended sharing mechanisms from 50-50 all the way up to 90-10 and several in between, correct?
Correct.
Now, so this case, OPC is recommending the 85-15 strictly on the fact that the legislature made a decision on a piece of legislation to do that on what many think is a different topic?
So I think that's a good question, and that does deserve a clarification. So going back to this slide, I'm just going back one slide to slide 5, addressing this shows our proposal versus what is existing now. Public Counsel has consistently believe that a higher incentive is needed in the FAC. The utility needs more skin in the game, not only to protect customers on the front end for when costs increase, but also to encourage the utility to continue to decrease costs going forward. You're right. There has been some different variations of request. Even staff at one point suggested 8515 in the past. Why we're picking 8515 now is because the legislature was silent when it first passed FAC. It knew that you guys needed discretion to decide what incentive was necessary, but it left that up to you. But it left it up to you. However, the legislature has not stayed silent. When it has most recently been debating how much skin is needed in the game, it drew on 85.
But the skin we talking about fuel adjustment clause, right?
Yes. Or the debate that I'm
Talking about
referencing to is
fuel,
piece.
right? This is the cost of the we're talking about a fuel adjustment clause, correct?
Yes.
Okay, but then the legislature did not address a fuel adjustment clause, right?
The legislature did not amend this. The legislature did not amend this statutory language regarding the FAC and what the incentive mechanism is. Correct. I believe
They did talk about 8515 on a different topic, a different subject, but it did involve utilities, correct?
correct.
Okay, but so you're making the case that because they made a distinction regarding a utility, it goes across the board? I mean, it should be in all costs?
Rate mechanisms are inherently an exception to the rule that I showed prior, which is that in a pure regulatory lag framework, there's just a 0-0 sharing. I think since we have the most recent manifestation of what the Missouri body politic is willing to bear, that is 8515. I think that deserves some due consideration. You are right, Commissioner, that they did not amend this language. The legislature did not decide to paternalistically tell you that this sharing in the FAC shall be 8515. But I don't believe it's because they wanted you to just maintain 95.5 and stay course with regulatory inertia. However, I do believe that this power was left to you because there are cases, not in this case with Ameren, that has been a good actor recently, but there may be cases where a higher sharing may be necessary. Say a 50-50 sharing ratio may be necessary if future evidence shows that a utility has engaged in prudent behavior or isn't pursuing every cost-effective measure possible.
And that makes sense. But we're not saying Ameren has been imprudent, correct?
Correct.
Okay, and the legislature told us how PISA standard would be handled at 8515, correct?
Correct.
Going forward, so they told us it's 8515 on PISA,
Yes.
but they haven't touched the FAC. That statute that you just said, and that's what we're dealing with, right?
So when you say haven't touched that statute.
I mean, they didn't change that statute. They didn't tell us what to do. They didn't go in there and say we want it to be 8515 on.
So, Commissioner Kenny, I'm not disagreeing with you, and I'm not meaning to
You're not.
quibble.
You're not.
There were amendments to the specific statute. So SB 564 did touch on that statute. So for the purpose of this
but I can
record,
tell you,
this
you're
language.
dealing with 5 senators. Offering an amendment doesn't mean much.
But so to answer your question and agreeing with you, this language that we're debating, that is the language that authorizes the efficiency incentive, that was not explicitly changed by SB 564.
I think we agree on all that.
Yes.
But thank you.
Mr. Chairman, you had a follow-up?
Yeah, thanks. Just to follow up on that, but the legislature clearly during that debate could have
amended this authorizing language regarding the efficiency incentive. Yes, it could have.
and they could have said 8515, which is what you're wanting us to infer when they were specifically silent. Is that correct?
What I'm asking you to consider from the language within PISA is that we now have some explicit guidance on what is the baseline sharing that is necessary to encourage a utility to engage in investment while still protecting customers. That is what the legislature decided was a fair sharing. I don't believe that the legislature.
Isn't it also fair to say that the legislature decided that was a separate issue by not addressing this when they specifically amended portions of this statute?
I can certainly see your argument, Chairman, and reasonable minds may disagree, but I believe that the legislature did not explicitly address this language for the hypothetical that I presented, that 8515 may be a baseline, but that there may be particular utilities that in certain instances, a different sharing mechanism may be required. Again, the FIC statute does not state that the efficiency incentive is to be uniform in all utilities. That is not to say we are targeting Ameren on this issue. You can read the pre-file testimony of Ms. Mantle in the ongoing Empire case, and we're raising the 8515 again.
So, following that line of logic, that the commission should have the ability to set the rate differently to address specific situations where utilities may need a higher cost sharing. What has this utility done that makes you believe that they should no longer have 95.5? Why are we now talking about this?
So there's two answers to that question, and I think those hit on key points. One is that, and with no offense to Ameren, they happen to be the first utility with a rate case that is initiated following the effective date of PISA. It would not have been proper to raise the PISA argument in KCPL's last rate case. We're raising it as the rate case has come in.
But you've raised the argument of changing this cost sharing in multiple cases over the years.
Oh, yes. But in this case, I do believe that there is frankly more basis than our past arguments. It's a lot less nebulous. We're actually able to point back to some specific guidance. And as a second answer to your prior...
Is it specific guidance, though? Or is it you're inferring guidance when the legislature was silent?
I see it as specific guidance as to what type of sharing was necessary to get legislation passed. Now, as a second answer to your point, though, so we've heard from Ameren's counsel that this $42 million figure, that is, the $42 million is real dollars according to Ameren's counsel. $42 million is how much money and prudently incurred costs that Ameren hasn't recovered over 10 years throughout the FAC. That is the 5% that is the 5% of the differential that was lost when cost increased over the past 10 years. If that is real dollars, then I wonder why Mr. Byrne in his rebuttal testimony refers to $218 million as not material regarding the affiliate transaction issue. If $218 million is not material, I don't think $42 million is an incentive. And so that's why we think that a higher incentive may be necessary.
I apologize, but I'm going to have to object. If Mr. Hall is going to testify about what the record says, I'm confident Mr. Byrne did not say $218 million. The $218 million disallowance that Mr. Schallenberg proposed was not material. So he's misstating the record, and I think since we don't have any other opportunity to deal with that, I want to make sure that the commission's aware of that.
I would invite that the commission can read the testimony now, and also I remind everyone that Mr. Byrne's going to be on the stand today, and we can address that.
The testimony will speak for itself at this point, or assuming that it gets entered into the record.
I have no more questions at this time.
Commissioner Root?
Good morning. Appreciate the shout out for the 1% from the last week's. And I guess this boils down to, going back to your comment about, the hearing we had last week. If a half a cent is not sending a price signal on a time of use race, are we sending a price signal strong enough to this company to, change their behavior or to incentivize their behavior? Is that kind of where you're going with this? There's not enough of an incentive for them to alter behavior at where these levels are.
I think that was the argument I was trying to make. I think you've restated more eloquently than I did.
I think you did well. I think the chairman brought up something like, has Ameren done anything, to show evidence and stuff that they haven't been prudent or done anything with not cutting enough costs or something? I can't remember exactly what you said, but and I don't believe that they have in this case. However, let's assume there's a scenario where there's a utility that has historically lost, let's say, $100 million in their hedging practices, and there hasn't been any change from that utility because there's not really an incentive because it kind of flows through the FAC. Do you envision that being a scenario where there's not strong enough of a price signal to the utility to change behavior and change their practices when they have continually just had and cost?
I can certainly imagine that in that hypothetical that is a scenario where a person could reasonably ascribe that type of behavior to a lack of incentive to decrease costs. I would need to know more particulars on why the hedging practice was adopted and what exactly we're dealing with.
Well, then I sincerely hope that in the future cases that may come before this commission, that your guys' office take strong consideration of your argument if certain situations like that were to present themselves.
Of course, duly noted.
Excellent, thank you.
Commissioner Holzman?
Thank you. So I had the benefit of actually being in the room when the 564 was being debated and discussed. And I think that it's very clear by the legislature not taking a specific amendment or action on this language. The intent was to allow for this commission to be the arbiter of that percentage going forward. And the fact that PISA is at 85.15 as the legislature's determination that that's where they wanted those percentages to fall for that particular section of the statute. Now, having said that, you've also said that Ameren hasn't done anything that has raised a flag or required to seek a change from the 95.5 or that they've done anything to abuse that. So my position would be this commission, because of that statute, possesses the ability to make those changes whenever we determine those changes are necessary. So I wouldn't automatically dismiss a change if a utility has shown behavior that needs to have an adjustment. But this case may not be that place to do it if by your own admission there hasn't been the behavior to necessitate it. So going forward, the scenario where you said 50-50 might be more appropriate to fix a problem. There's nothing in that statute that prohibits us from making that determination, except for the circumstantial evidence that would require it at this time. So I'm open to future changes, but I would like to see the evidence behind the utility's behavior that's necessitating them.
I can certainly respect that response, Commissioner Holzman, but if I may, I think a realistic consideration for our office is that we needed to demonstrate that our suggestion that the FAC the sharing mechanism should be changed, we need to demonstrate that it's sincere. We can't just say, well, 17th time's the charm. No, if we had not, there's a reason why this is one of the last remaining issues to be litigated. If we hadn't raised this issue for this case, when it came up in Empire, this commission may reasonably judge us as not being sincere in our arguments and that we're just picking on Empire. I think Ameren is correct that regulatory consistency is a key to good governance. So we are asking that the FAC incentive be changed for not only Ameren.
But if regulatory consistency were the paramount subject, the legislature would have changed this statute and made it consistent with PISA. The fact that they didn't means that consistency is not the most important aspect here, and that our judgment of being the representatives for the commission to make these determinations is what is important in the going forward. So if Empire has a different set of circumstances that has your office saying we need to have an adjustment here, that's up to us to decide whether that evidence is there to agree with you. Not necessarily just saying we need to make a change for the sake of future cases that may requisite it.
Commissioner Holzman, I don't believe we actually disagree on that point, and you certainly have more firsthand knowledge of what was discussed on the Senate floor versus my own. But we agree that the legislature maintain your discretion. They have not paternalistically told you that FAC shall remain 95.5 regardless of changes. From Ameren's filing reduced its fuel cost, like that when it filed this case, it reduced its fuel costs, its net-based fuel costs, $108 million. That was a good thing. Utilities should be rewarded for good behavior, and that is what an 85-15 proposal does.
Apparently not according to the utility in this particular instance, maybe in one in the future. They may see a benefit in making that change, but now they're in opposition to that change, and without any evidence of saying that it's requisite. I think that my position would be open to that change in the future. So if your office sees it being evidence as being present, I encourage you to continue to have this discussion, but that's the position that I feel we're at this juncture. Thank you.
Commissioner Roop, you had another question?
Yeah, I did. I wanted to follow up on Commissioner Holzman's question. Would your office take issue if this commission decided that the FAC amounts was not uniform for all utilities? If we looked at it as an incentive to the utility and we had made adjustments to those based off of the actions of that utility? Or do you think, from your office standpoint, that all utilities needed to be treated the same when it comes to the FAC?
Oh, see, you never want to ask an attorney an ever or a never question because they'll never give you a straight answer. But what I can tell you is I see nothing in this statute that prohibits that type of regulatory framework where an FAC sharing mechanism may be different for one utility versus another. Again, that's left to your discretion. That's not what we're asking for at this time.
Any other questions, commissioners? All right, Mr. Hall, you may step down. At this time, I'd like to go ahead and take a short break. We're going to break for 10 minutes. And then when we return, we're going to try to continue with all the witnesses and maybe even finish before agenda time. We will stop at probably around 10 till noon for agenda. So let's go ahead and take a short break and come back at 10:15.
We're
Okay, we're back on the record after our break, and we're ready to begin with witnesses. Ameren?
Your Honor, we call Andrew Meyer to the witness stand.
Mr. Meyer, could you please raise your right hand? Do you solemnly swear or affirm the testimony you're about to give at this hearing will be the truth?
I do.
Thank you. You can go ahead, Mr. Lowry.
Thank you, Your Honor. Mr. Meyer, would you please state your name for the record?
Andrew Meyer.
Did you cause to be prepared for finding this docket 3 pieces of testimony, direct, rebuttal, and surrebuttal, which have been marked for identification as Exhibits 6, 7, and 8?
Yes,
Do you have any corrections to any of those testimonies?
I do not.
If I were to pose the questions that appear in those testimonies to you today, would your answers be the same as given in the testimony?
Yes, I would.
Mr. Meyer, could I get you to move that microphone so that you're speak there? Thank you.
With that, Your Honor, I offer the direct, rebuttal, and surrebuttal testimonies of Mr. Meyer, Exhibits 6, 7, and 8, and tender the witness for cross-examination.
Would there be any objection to Exhibits 6, 7, or 8? Seeing none, then I will admit those exhibits. Is there cross-examination by staff?
Nothing, Judge.
Consumers Counsel?
Sure, Your Honor. Good morning, Mr. Myers.
Good morning.
My name is John Kaufman. I represent Consumers Counsel. And let me just ask you a couple of preliminary questions. Is the fuel adjustment clause sharing mechanism a mechanism that allocates cost or allocates risk?
My understanding of the fuel adjustment clause mechanism is that it's designed to allow utilities to recover prudently incurred fuel costs.
But the sharing mechanism itself is a mechanism that allocates risk between the utility and its shareholders and the customers on the other side, correct?
Yeah, there's an incentive aspect to it, yes.
And so when we're talking about 95%, 5%, we're talking about which of the two sides of the scales here have to bear the risk of volatility, correct?
And cost.
Right. And that translates into cost, and it can be up or down. But can you tell me why you think it's fair that customers have to bear 95% of the volatility of fuel cost in between rate cases?
The utility has an obligation to serve affordably, and we have this generation fleet, that's there, that's a least cost solution. So we try to operate it, to provide reliable service.
And the utility has some control of where those fuel costs land, correct?
We have a hedging program for most of the commodities we manage, but that doesn't get us to 100% certainty. And that hedging program only impacts the rate that we might pay. There's still another aspect of the calculation of the volume. It's rate times volume is going to get you the total costs, and the volume of fuel consumed can fluctuate for its own whole host of reasons, just like the rate can.
How many employees, how many FTEs does Ameren employ to manage fuel cost?
Specifically in our fuel procurement group, there's 10 to 12, I guess.
Okay. And I assume that they're not just sitting around just watching the numbers come in. Those folks have to pay attention and make decisions to try to keep those costs under control, correct?
Absolutely.
Right. And so you would concede, would you not, that Ameren has some control and those 10 employees exercise control and try to manage those costs?
We do not control the market. The market fluctuates with supply and demand, at its own will. We're a very, very small component of that. If you're talking about the rates that we pay for specific commodities, yes, the hedging program allows us some influence over the rate. the volume is still largely in question.
And the decisions that those 10 employees make have consequences for how the numbers actually fall out in the fuel adjustment clause, correct?
Yes?
Okay. And do customers have any control over the hedging, over the volume or the rates at all?
The fuel adjustment clause rates?
Yeah. Do customers have any control over how those costs fall out in the fuel adjustment clause charges that they have to pay?
No, they do not.
So why is it fair that customers have to bear 95% of the risk of those decisions?
Because they're costs that are prudently incurred to result in a benefit to the customer.
So you would agree with me that the 95.5 is a risk sharing. I mean, I guess you could look at it as a cost sharing, but it's also a risk sharing, right? The risk of volatility, the risk of fuel costs changing over time, correct? That is under this mechanism, the change is borne 95% on consumers, 5% on the utility under the current mechanism. Is that?
Your Honor, I'm going to object. It's asked and answered about 3 times
I don't
already.
think I got a straight answer.
I'll allow him to answer.
Yes, there's some risk on both parties.
And when you allocate, risk doesn't go away by putting into a mechanism. It's transferred from one side to the other, right? If you were to change the current mechanism from 95.5 to 85.15, that would be transferring some of the risk from customers back to the utility, correct?
Yes.
I mean, risk is a zero-sum game. You agree with that?
Sure.
Right. And so Ameren is, would you say that Ameren is comfortable with only having to bear 5%? Or would you desire that to be 0%? Would you like consumers to bear 100% of the risk?
No, we propose keeping the status quo mechanism.
I mean, Ameren didn't like any percentage originally, right, in 2008, 2009? But you've grown accustomed to 5%. You can live with it, is that fair?
That's correct.
Okay. And would you concede that it is a symmetrical mechanism? So if the mechanism is changed to, say, let the utility bear 15% of the risk of fluctuation, would some years financially, would that benefit the utility and some years not? It could go up or down. Is that fair?
Yeah.
Okay. But you don't believe that that small change from 5 to 15% would incent any more cost-effective behavior?
We have a whole list of reasons why we try to reduce fuel costs as much as we have. I mean, it starts with the fuel adjustment clause in and of itself, as you described earlier. It's a privilege, not a right. And so we totally recognize that we come forward and ask for it in every one of these occasions. And if we're not acting prudently, it could just be taken away entirely. And then probably the next biggest reason is the prudence review mechanism. When we're making economic decisions, we're not considering 5% of the exposure. We're making economic decisions on the full notional value, and if that decision is deemed to not be prudent, we expect staff to identify it in a prudence review, and we expect the commission to disallow it.
Right. So I know you're not a lawyer, but I assume that you're intimately familiar with the fuel adjustment clause statute. Have you read it?
I've read it.
Okay. And so you're familiar with the provision that was projected up there that talks about the incentive mechanism for cost effectiveness, right? And that provision doesn't say that should be based on bad acts or abuses by the utility, does it? It's not set up as a penalty.
Objection to the extent it calls for a legal conclusion about what the statute is set up to do or not to do.
I agree.
I'll withdraw.
Thank you.
Is it your opinion that Ameren should not have to bear any more than 5% of the volatility risk unless it has been caught red-handed with some imprudence finding? Is that?
Well, we already, in the instances where something is deemed to be imprudent, we already bear more than 5%. again, it's whatever that decision, the notional exposure of that decision was, I expect the full amount of it to be disallowed.
Okay. All right, well, let's just take all the other considerations we talked about aside. If the sharing percentage if it were changed to say 50-50 sharing, there would still be volatility, but it would be smoothed out over time, would it not, for consumers, from what it is currently? Right.
Volatility in what? The actual fuel adjustment clause rate?
In how much of fuel cost changes consumers have to bear. I mean,
Oh, who's paying the bill? Yes.
this is what I'm trying to get at, and tell me if you agree. Is the sharing percentage, in one sense, is about volatility, right? How much customers should have to bear as far as fuel cost changes in between rate cases.
It's an allocation of who's going to pay for prudently incurred costs.
Right. And over time, the more risk that consumers are asked to bear, the more volatile those rates are likely to be in between rate cases. Is that fair?
I'm not sure I get to that conclusion.
Do you understand the fuel adjustment clause to be a volatility allocator, an allocator of volatility?
No, I consider the commodity markets themselves to be volatile and uncertain. The rate is, to me, it's a reflection of what actual costs were when compared to the base that was set in the rate case.
Okay, and so it's your opinion that customers should bear 95% of that actual volatility in fuel cost?
We've asked to keep the sharing mechanism the same, yes.
If that sharing percentage is changed to allocate some of the risk back to the utility, would that not result in a smoothing out of the fuel adjustment clause changes for consumers over time? The increases won't be as high and the decreases won't be as low. Is that fair?
If you're asking me to assume that the deviations from the base factor are always the same and they share in less of the cost, then yes.
So which side do you think is better, from the customer side and the utility side? Which side is better able to absorb volatility and costs on average? Or take my mother, for example, living on a fixed income. Do you think that she has the financial tools to mitigate changes in her rates as well as the Ameren, Missouri utility?
I don't know.
Okay, fair enough. That's all I have.
Thank you. Public counsel?
Thank you. Mr. Meyer, good morning.
Good morning.
Help me out here. So, am I getting this right? You're the senior director of the Energy Management and Trading. Is that a group within Ameren, Missouri?
It is.
How many people are in that group?
Roughly 50 people, but not all of them are devoted to FAC management issues.
Okay. Do you oversee all of those people?
I do.
Is there anyone above you in the Energy Management and Trading group?
I report to the Vice President of Power Operations and Energy Management and Trading.
Okay. How long have you been in that trading group?
I've worked in that trading group essentially my whole Ameren career, which is 21 years now.
21 years. Have you always been with Ameren?
I had a job previously, but no.
Your testimony says you were employed with Continental Grain Company. Is that correct?
That's correct.
I was looking into them. They're headquartered in New York. Were you in New York or were you working in Missouri?
I was working in Memphis.
Okay. Thank you. When I hear Continental Grain Company, what were you doing there?
My role was a grain merchandiser, so I would procure grain from local farmers or small elevators, and then we would resell it for export purposes.
So you were like trading commodities. Is that a fair description of your job? You were working with trading commodities.
It was a procurement function.
And how long were you in that job?
About 2 years.
Mr. Meyer, do you have a copy of your testimony in front of you?
I do.
Could you turn to the schedule that you attached in your rebuttal, AMM-R1?
I have it.
I don't want to come across as rude in this question, but so this was attached to your testimony. Did you prepare this table?
No, it was prepared at my request.
Okay. Did you review the cases that are listed in this table?
No, not each one individually.
Am I hearing correctly? You didn't review the first one that's listed, ER-2007-0002?
What do you mean by review? Did I read all the testimony? Did I? No.
Fair
I did
point.
not.
Did you read the report and order for that rate case, ER-2007-0002?
No, I did not.
You didn't read that in that case, the commission actually did not approve an FAC?
I did not read that, no.
Your Honor, at this time, I would ask that the commission take notice of its report and order from that aforementioned docket, just as the commission has with all the other dockets listed.
Hold on just 1 second. Would there be any objection to the commission taking notice of the report and order in ER-2007-0002?
None here.
I assume, Your Honor, the entire report, and I don't care, but the entire report and order or just the FAC section?
Since we don't have it before us, I'd say the entire report and order.
No objection.
Okay, I will take notice of that.
Thank you, Mr. Meyer. No further questions.
Are there any commission questions for Mr. Meyer, Mr. Chairman?
Yes, thank you. How often under the current FAC have you seen over recovery versus under recovery?
I just read those statistics here recently in Lena's testimony, I believe, but I think for the first part of us having an FAC, for roughly the first several years, it trended towards an under recovery, and so we were collecting back additional actual expenses from customers, and most recently it's sort of switched to an over recovery, so we've been offering refunds.
Okay, thank you.
Commissioner Kinney?
Thank you. On your rebuttal testimony, pages 12 and 13, on line 17, you said there's a distinct minority of utilities having sharing of cost at all. And then, so I just had a question. In vertically integrated states, how many utilities have FACs?
I don't have an exact answer for you. I'm sorry.
You don't know?
I don't know.
I mean, on the question on page 15 says, how would an even greater sharing percentage for Ameren, Missouri compare to the FACs of the other 97 utilities operating in non-restructured states? That's on page 12, question 15. So I would assume if I took that, that'd be like 98. I guess my question is, how many of those utilities, do you know how many of those utilities have a sharing mechanism?
The company commissioned a review of this. It's probably been 3.5 years ago, where we broke it all out and identified sharing mechanisms. I just do not have the exact number of how many actually have a sharing mechanism for you.
Do you happen to know how many have a sharing mechanism greater than 5%?
Again, I don't have the specific details of it.
Okay, well, the reason I'm asking those questions is because you said that I'm going to try and understand what it is, that a distinct minority of utilities have sharing of costs at all. From an investor standpoint, and from the standpoint of putting Missouri electric utilities on comparable footing with their peers, even the 5% share of net energy cost increases that Missouri utilities must bear places them at a disadvantage. So I kind of want to know, what is that disadvantage And how does that, what encompasses that disadvantage that you feel that Ameren has that other companies that don't have a cost-sharing mechanism don't have?
So in terms of a disadvantage from a utility that recovers 100% of their costs versus, in this case, Ameren Missouri, that recovers 95%, I think the disadvantage is in the investor perspective. So if you look at a utility that, there is that has a fuel adjustment clause mechanism that may not allow it to recover 100% of its prudently incurred costs, or a fuel adjustment mechanism that is subject to change with any frequency. If I'm an investor, I would look at that and say, that's just another indication that the utility may not be able to earn its allowed return on equity.
Okay, given the amounts we're talking about and the size of Ameren, would that be considered de minimis?
Well, the number that we've been throwing about, again, it's over 10 years, it's $42 million, so I don't consider that number de minimis.
Okay, $42 million over 10 years? Okay, all right, thank you.
Commissioner Roop, any questions? Commissioner Holzman? Oh, I'm sorry, Commissioner Coleman. Did you have any questions? Commissioner Holzman?
If cost sharing were to go to 85-15, do you think that would hasten the shuttering of coal plants?
The decision to shutter any coal plants is really a long-term resource planning decision.
Given the scheduling issues and, you don't think that it would provide an incentive to close the coal plants faster than they would have otherwise?
No. When you're looking at the fuel adjustment clause costs, we're looking at this short-term view of the market, on an hourly, daily, maybe up to a year basis. But that decision to close the coal plant really is a long-term planning decision. So I don't see any connection there.
All right. Thank you.
Thank you. Are there any additional cross-examination questions based on questions from the bench? Staff? No. Consumer Counsel? Public Counsel?
Yes, briefly, thank you. Mr. Meyer, in your conversation with Commissioner Kenny, you noted a hypothetical investor may look at an 85-15 sharing and think that that's an indication the utility may not reach its authorized return. Am I characterizing your answer correctly?
Yes.
Are you saying that Ameren Missouri is reliant on a 95-5 sharing to reach its authorized return?
No, there's multiple factors.
Thank you. No further questions.
Is there any redirect?
Just a little bit, Your Honor. Your Honor, if you'll indulge me, that we didn't anticipate this question, but Commissioner Kenny had a number of questions about how many other utilities and the 97 utility figure. I have the work paper that Mr. Meyer relied upon for that with me. If we can get the commission copies. I obviously can't give you a copy off my computer, but I'd like to refresh his recollection about that.
Would there be any objection?
Not an objection, but could the other councils see this document before?
You've seen it in discovery, at least in the last case.
This is a work paper for...
It's the survey. It's the survey he referred to. The bottom master file. Okay. Mr. Meyer, you recall, I'll let you operate the computer. You recall Commissioner Kenny asking you some questions about other electric utilities and the sharing percentages that they did or did not have in their fuel adjustment clauses. Do you recall that?
I do.
And your testimony indicates that there were, I believe, 97 other electric utilities that have fuel adjustment clauses. Is that right?
That's correct.
And is this document in front of you, which we can provide to the commission? You've mentioned something about the company commissioning a survey about three and a half years ago. Is this the source of the information that you have in your testimony and that you were discussing with Commissioner Kenny?
It is.
Can you share with Commissioner Kenny, I guess, some statistics that might answer the questions that you had?
So there's a line item in here, the FAC passes through 100% of cost changes to ratepayers, at which point in 2015, 80 utilities had an FAC that had that mechanism.
Out of 97.
Correct.
And would those have included the Missouri utilities that had 95.5?
That passed through 100%?
Actually, a bad question. The 17 that had something other than 100%, would they have included the Missouri utilities?
Yes.
Any other statistics there that were responsive to Commissioner Kenny's questions? Thank you.
No.
We'll get copies, Your Honor, mark it as an exhibit if you'd like.
I don't think it's necessary unless the other parties would like it in the record.
We can, or we don't need to. I'm just offering it up.
I believe it's a witness is entitled to look at a document to refresh its memory. This is refresh his or her memory rather. Unless if Ameren wishes to admit it, we have no objection, but we have no preference.
We don't need it then, Mr. Lowe.
Thank you. I'm going to go in reverse order, just a couple questions. Commissioner Holtzman asked you about whether or not changing the sharing percentage would have something to do with the economics of the coal plants, right? In terms of when they might be decommissioned or not decommissioned. You remember that?
I do.
When you are making decisions about committing the units or at what incremental cost you would bid the units into the market, does the sharing percentage have anything to do with those decisions?
No, absolutely not. I mean, when we're making unit commitment decisions, we're considering the full notional value of the decision. And so if we're deciding whether or not a unit should be turned on and operate in the market for tomorrow, we're doing a daily evaluation to try to inform us on what's in the best interest of the customers. Should it be running? Will it create a positive margin for them or not?
So if the company was bearing a greater percentage of changes in the FAC, but the unit was economic for customers, then the company's going to continue to run the unit, right?
That's correct.
You were asked some questions, I think they were by Mr. Kaufman primarily, about the 95.5 versus the 85.15. And he was trying to get you to, I think, indicate that the 95.5 is, in your mind, the right sharing percentage. Do you remember those questions?
I do.
What's your position on whether there ought to be a sharing percentage? In the absence of the commission having made this decision for the last 11 years, what would have been your personal opinion about having a sharing percentage in the FAC?
My personal opinion is that we don't need any sharing percentage. I feel like we have our processes down and we have all the, such that the unit commitment decisions we're making those decisions in the vein of what benefits customers most. And in terms of incentive to keep the fuel costs down, I mentioned in a previous answer, I feel like we have a list of reasons to incentivize us to manage our fuel costs efficiently.
Mr. Kaufman asked you some questions about control over who has relative control over the various components. Do you remember that?
I do.
And I think you answered, you did mention hedging that the company does, right?
Yes.
Is hedging your fuel needs at a given time, does that equate to control or are they different things?
Oh, it's not control. I mean, the point of the hedging program is to narrow the range of possibilities on what the ultimate expense may be. But again, you're only providing a fractional amount of certainty on the rate component. The volume can still change, and so the ultimate expense, we have no control over that.
You were asked, I think, questions by Mr. Kaufman and by Mr. Hall about the number of employees you have in your group. Do you remember those?
Yes.
I think Mr. Kaufman was more specific. He was asking, I think, about employees that deal with fuel. Do you remember that?
Yes.
How have the decisions those employees made recently, how have they manifested themselves in this rate case?
Well, again, it was previously mentioned in the opening statements, but if you look at what we've done with net fuel costs, I mean, they've come down dramatically. So a comparison of net base energy costs in this filed case compared to net base energy costs in the filed case from 2016, but they've been reduced by $108 million.
And what was the sharing percentage that was in place when you were taking those steps to reduce net fuel costs by $108 million?
It was 95.5.
Just to be clear for the record, would your actions have been any different if it was 100-0 or 85-15?
They would not.
I think that's all I have, Your Honor. Thank you.
Thank you. Thank you, Mr. Meyer. You may step down. Ameren like to call its next witness?
We call Tom Byrne to the stand.
Do you solemnly swear or affirm that the testimony you're about to give at this hearing will be the truth?
I do.
Thank you. Can go ahead, Mr. Lowry.
Please state your name for the record.
Tom Byrne.
Mr. Byrne, did you cause to be prepared for filing in this docket direct and rebuttal testimony and rebuttal testimony marked for identifications as Exhibits 2, 3, and 4?
Yes, I did.
Do you have any corrections to any of those testimonies?
No.
If I were to pose the questions that appear in those testimonies to you today, would your answers be the same?
Yes.
With that, Your Honor, I offer Exhibits 2, 3, and 4 and tender Mr. Byrne for cross-examination.
Would there be any objection to Exhibit 2, 3, or 4?
None here.
Seeing none, then I will admit those exhibits. Is there cross-examination from staff?
No, Your Honor.
Consumers Counsel?
Oh, I'll pass on Mr. Byrne for today, thanks.
Public Counsel?
No questions, thank you. Good morning, Mr. Byrne.
Good morning.
Are there questions from the commission for Mr. Byrne? All right, well, I'm sorry. Commissioner Roop, go ahead.
Morning. Good morning. Do you feel that $218 million is a relevant number?
No, it's a huge number.
It's a huge number. Is $42 million a relevant number?
It's a huge number. It's very relevant.
It's not a rounding error?
It's not a rounding error.
Thank you.
All right. Is there any further cross-examination based on commission questions from staff?
Nothing.
Consumers Counsel?
No, Your Honor.
Public Counsel?
None, thank you.
Is there any redirect?
Yes, Your Honor. Mr. Byrne, Commissioner Roop just asked you about the $218 million figure, and I assume that he probably asked you that because of what Mr. Hall said during his answers to his questions. Do you recall that?
Yes.
Did Mr. Hall fairly characterize your rebuttal testimony when he indicated that you said that $218 million was not material?
No, he didn't.
Could you turn to page 2, lines 22 and 23 of your rebuttal testimony, please?
Okay, I'm there.
When you said that Ameren, Missouri has no material level of transactions with unregulated affiliates, to what were you referring?
I was referring to the affiliates other than AMS. I basically was counting AMS as effectively a regulated utility, and as you can see in the next sentence, I say nearly all of the services Ameren, Missouri receives from affiliates, about 97% of the dollars are with Ameren Services Company. So I wasn't, when I said it wasn't material, I wasn't talking about the Ameren Service Company dollars, which was the $218 million.
Thank you, Mr. Byrne. I have no further questions, Your Honor.
All right. Thank you, Mr. Byrne. You may step down. I believe that concludes all the scheduled witnesses for Ameren. We can begin with staff.
Staff calls Lisa Wildhaber.
Do you solemnly swear or affirm that the testimony you're about to give at this hearing will be the truth?
Yes.
You may go ahead with your direct, staff.
Good morning.
Good morning.
Would you please state and spell your name for the record?
It's Lisa Wildhaber, Lisa Wildhaber.
By whom are you employed and in what capacity?
I am a utility regulatory auditor with the Missouri Public Service Commission.
Are you the same Lisa Wildhaber who caused to be prepared certain testimony which has been marked as rebuttal testimony, Exhibit 123?
Yes.
Do you have any changes or corrections to your testimony?
No.
If I asked those same questions to you today, would your answers be the same?
Yes.
Is your testimony true and correct to the best of your knowledge?
Yes.
Judge, we offer Exhibit 123.
Would there be any objection to Exhibit 123? Seeing none, I will admit that.
And we tender Ms. Wildhaber for cross-examination.
Is there any cross-examination by Ameren?
Thank you. Good morning.
Good morning.
I don't think I've met you before, so nice to meet you. Did staff review the testimony filed by OPC witness Lena Mantle in this case?
Yes.
Did staff review Ameren Missouri's NBEC calculation?
Yes.
In reviewing Ameren Missouri's calculation, did staff find any evidence that Ameren Missouri had artificially manipulated the results?
No.
Is the fact that actual results turn out different from a projected number evidence that the party manipulated the results?
No.
I have no further questions.
Are there any cross-examination from Consumers Council?
Yes, Your Honor. Good morning.
Good morning.
How long have you been working for the staff on this particular issue of fuel adjustment clause mechanism issues?
I began employment with the commission in June of 2018.
Okay. So you weren't here when this new version of the fuel adjustment clause was adopted in 2009?
Correct.
Right. So I guess all you've ever known is the 95.5% sharing mechanism, correct?
Correct.
And you weren't here when the Public Service Commission decided that small utilities would have a fuel adjustment clause, but large utilities didn't need it? You don't recall that?
I'm going to
not aware of
object that this is assumed facts, not in evidence.
Which facts?
I don't know what facts.
Well, he said you weren't here when the commission in 2009 determined blah, blah, blah. There's no evidence in the record about what the commission determined in 2009.
I think there is evidence or at least judicial notice of orders that refer to this. It's
I
admitted,
think that
in the
evidence is in the record. She can answer.
So are you aware of previous decisions where this commission has decided that the fuel adjustment clause should be based on whether electric utility is large or small? Do you remember reading any of those previous decisions?
Your Honor, I know you overruled my objection. I read all of these orders. I don't know of any of them that talk about small or large utilities. So I don't think it's in the evidence, if there's any evidence about this in the record.
Okay, the original question was about the 80, about the percentage.
As I understand administrative law in Missouri, is that cross-examination does not have to encompass only the evidence that's been in the record. My question is, are you aware of decisions by the Public Service Commission regarding whether the size of a utility matters as to whether the fuel adjustment clause is allowed?
Okay, that's stated just a little bit different. Ms. Tatro, is your
He can pose a
objection?
hypothetical, I suppose, or he can provide her for a basis for his statement, but he can't testify in asking a question.
Okay.
And there's no evidence in the record.
My question is, does your objection still stand to the question that he just asked, which was, is she aware of such decisions?
I'm okay with that sentence, that question, thank you.
I will allow her to answer.
I am not aware of that.
So have you read previous fuel adjustment clause decisions by this commission?
I have read some, yes.
How many have you read? Have you read decisions going back to 2007?
I don't think I read back to 2007, no.
All right. Do you understand the sharing mechanism to be an allocation of risk between the utility and its customers?
I understand it to be a mechanism designed to give the company an incentive if they appropriately manage their fuel and purchase power costs.
Right. And the statutory provision that allows this incentive mechanism refers to incentivizing cost effectiveness. Is that fair?
Judge, objection. This calls for a legal conclusion.
Can you?
I don't think it does. I can rephrase.
Go ahead.
In your mind, is the sharing mechanism that has been adopted in several cases, is the idea of a sharing mechanism designed to promote cost effectiveness, in your opinion?
I think so, yes.
Okay. And do you believe that the sharing mechanism is a tool that's designed to punish a company that has abused the system? It's not designed to be a penalty, is it?
I can't address whether it's penalty, punishment. I think I've said what my understanding is.
Okay. But, and staff in previous cases has recommended a sharing mechanism of 85-15%. Is that correct?
That's my understanding in cases past.
Mm-hmm. And why is staff comfortable with 95.5% currently?
Because staff has seen no evidence that we haven't seen a pattern of imprudence in the prudence reviews that would cause us to consider that the 95.5 needs to change.
Are you aware of any rule or law or regulation that says that customers have to bear 95% of the risk until the company is caught red-handed with an imprudence?
Judge, this is argumentative, this red-handed language.
That's exactly what
I'll allow her to
related to
answer.
a previous question.
Objection overruled. You can answer.
Can you restate the question?
So, is it staff's opinion that customers have to continue to bear 95% of the volatility until someone can catch Ameren red-handed with some imprudence in their fuel procurement practices? Is that what it would take for staff to come off of the 95.5% recommendation?
Staff would need to see a pattern of imprudence. Whether you classify it as red-handed, I can't address that.
So how is that related to cost effectiveness? Can a mechanism promote cost effectiveness without there being a pattern of abuse or imprudence?
I don't know. I don't know.
But you're telling me that, in your opinion, the commission that this should continue to be allocated 95% on customers and only 5% on the utility until there is an imprudence finding.
A pattern of imprudence that would make us look.
So more than there would need to be more than one imprudence finding. Is that what you're saying?
I can't say how many it would take. I don't know.
Has staff ever, let me ask this. How hard is it to make a prudence finding under the current regime?
We review a lot of information. I don't know how to quantify that.
Have you ever proposed a disallowance based on imprudence?
I have not since I've been here, no.
Are you aware of any attempt by staff to make a case for imprudence with Ameren?
With Ameren, I know in the past there has been, yes.
And when was that?
The exact dates, I know the case numbers were 2010 and 2012.
And what happened in that situation?
I know it involved off-system sales revenue and the inclusion of certain contracts as revenues to flow through the FAC.
And was that issue resolved by a settlement, or did the commission decide that
I don't know.
issue? Okay. That's all I have. Thank you.
Is there cross-examination from public counsel?
Yes, thank you. Good morning, Miss Wildhaber, am I saying that correctly?
That's close, yes.
I have a weakness with names.
That's all right.
If I mispronounce your name, I want you to correct me. Can you do that?
You're good.
Ms. Wildhaber, you were just asked about your current duties and positions. How long have you been with the commission as an auditor?
As I mentioned, I was employed, I started employment June of 2018.
Oh,
So it will be 2 years.
I must
It
have
will
missed
be
that.
2
Thank
years.
you.
Yes.
Help me with the terminology. Would you say is there an auditing group or an office? What is the structure of your place and staff right now?
I'm an auditor with the Energy Resources Department. There is a separate auditing department with the PSC.
So your position within Energy Resources has an auditing group, and that group is responsible with looking at response to FAC prudence filings.
Correct.
Does your group also deal with MIA prudence filings? Missouri Energy Efficiency Investment Act prudence filings.
Yes.
You also deal with resource planning reviews as part of the integrated resource plan process?
We don't have active involvement with the IRP, or the department does, the auditing group does not.
Okay, so
that
not
I've
your
been
group.
involved with.
Your
Yes.
internal group would not be related to the IRP planning process then?
Not the internal group of auditors.
What about prudence filings per the Renewable Energy Standard Rate Adjustment Mechanism, or RESRAM, under Missouri's Renewable Energy Standard?
I have not been involved with that, no.
And given your current position sitting here today, I'm going to assume that your group is also involved in general rate case filings as well.
Correct.
And you did auditing as part of this case as well.
Yes.
Are you also involved in the true-up filings that occur in the rate cases?
Not as heavily as the actual auditing department.
And along with all of those responsibilities, there's the internal administrative duties that have to be done within your group as well, correct?
Yes.
So a prudence review under the fuel adjustment clause, that takes 6 months? Am I remembering correctly?
I think approximately, yes.
Is that an internal goal, or is that prescribed by rule?
It's prescribed by rule.
And for those 6 months, your department is dealing with all these other duties, correct?
All that you have mentioned, yes.
Other than IRP, which you pointed out you aren't.
Correct.
Your Honor, may I approach?
Go ahead.
Oh, no, I didn't run out of staples. Oh, actually, could I have that one to give me?
I've got it.
Oh, you don't need one? Oh, okay. For the record, I have just presented the witness with a copy of the 7th prudence review of Ameren's fuel adjustment clause. I believe this is already in the record per a motion from Ameren, Missouri.
What is the case on
Oh,
that?
of course. EO 2019-0257. Ms. Wildhopper, will you please turn to pages 30 and 31? There is a confidential and a public version, but we will only be discussing public matters. Am I reading correctly that you contributed to this portion of the report regarding FERC accounts 565 and 456.1?
Correct.
And what is this a review of?
It has to do with transmission costs and revenues.
Can you explain that broader? Like, why are these two accounts focused on?
Because it's part of what comes under costs and accounts that flow through the FAC.
In this review, you found no imprudence activity on the part of Ameren, correct?
Correct.
There's a list, I'm looking at subheading 4 on page 31, there's a listing of documents reviewed. Am I understanding correctly, this is the scope of your review for this one issue?
These are the documents I reviewed.
So you looked at data requests, correct?
Yes,
You looked at work papers,
yes,
correct? Monthly reports during the review period, correct?
Yes.
And you also looked at general ledgers and journals during the review period.
yes.
So that's that's only a list of 4 things. How large were those documents, though, just for this issue?
I don't know offhand how large these were. The monthly reports are extensive.
Did you look at what other companies' activities were regarding transmission cost and revenues in your review?
Other companies besides Ameren you're talking
Yes.
about? No.
Did you look at activity in other regional transmission operators in your review?
As part of my review, no.
And other than these 4 listed documents, was there anything else that you reviewed to come to your conclusion?
I don't know offhand. I'd have to go back and review.
Do you believe that staff would have been able to review more documents if it had more than 6 months to review in a prudence review? I realize I said review 5 times in that sentence.
Can you ask that again?
Of course. If a prudence review was longer than 6 months, do you think you could have reviewed more than 4 documents, or 4 lists of documents, I should say?
Yeah, I reviewed more than 4 documents. I don't know. I haven't experienced that, so I don't know.
Ms. Wildhopper, will you please turn to pages 34? And I believe your conclusion is ultimately on pages 37 and 38. Is this another portion of the staff report that you contributed to?
Yes, with another staff person.
The caption heading is FERC 447 off-system sales revenue. What are you looking at for this one issue?
I think the report, that section explains what all was looked at for, I don't know how detailed you want to get with that.
Well, pretend I'm... What is the action for this issue that staff is trying to decide whether that action was prudent or imprudent? Is the question, was Ameren prudent in exercising off-system sales? What exactly are you looking at for this issue?
Well, I looked at all the documents that are listed there, and included in that is looking at the general ledger for line-by-line transactions of what went into the off-system sales revenue that flowed through the FAC.
And this is the same general ledger that you looked at for the previous issue we discussed?
Different accounts, but yes.
Different accounts, but actually, let's focus on the documents reviewed. For this one issue, you again looked at, I'll just be quicker this time, you looked at data requests, the general ledger we discussed, work papers, certain MISO schedules and tariff modules, and you looked FERC definitions from a federal government website. Am I reading this correctly?
Yes.
Was there anything else that was considered for determination on this one issue?
I think that list is at least the majority of them.
let's focus on page 36 for make whole. There's a subsection on make whole payments. What are make whole payments?
Do you want me to read what I've got there?
Can you try it? Explain to some.
It has to
pretend
do
I'm
with
five. I
making,
really don't
it
know.
has to do with making, in general, it has to do with making the company whole when there are price drops or price inconsistencies out of their control when they are forced to, or when they do participate.
Am I understanding correctly? These are entries Ameren makes, like you said, to make itself whole because of its responsibilities to its regional transmission operator?
I don't think I understood the question.
Allow me to restate it. Am I understanding that these make whole payments are necessary to, again, make Ameren whole because of it costs it incurs simply because it's operating within the MISO regional transmission operator network?
I would say probably yes. In general, yes.
Okay. On lines 21 through 23, you talk about your review. It says staff only reviewed these transactions for accounting accuracy. What does that mean, accounting accuracy?
That would mean, as far as the appropriate, to make sure that the costs that went through the FAC were appropriate based on the FERC accounts, the sub-accounts, and reconciliation between all the sources of information for this OSSR.
So you're reviewing the information the company's given you?
What the company is providing everyone
Yes.
as far as monthly reports and
Does this accounting accuracy review look at the experience of other utilities over this same time frame?
I did not look at that, no.
And it doesn't look at what's occurring in other regional transmission operators?
Again, I did not look at that, no.
Ms. Wildhopper, were you in the room during my opening? Or when?
Yes.
Did you hear my quoting of Mr. Laney's testimony?
I heard it, but I couldn't repeat it back to you.
Your Honor, may I approach again?
Yes.
Ms. Wildhopper, I was quoting from page 4. If you wouldn't mind reading lines 5 through 8. Or, no, 5 through 7.
Due to the highly confidential nature of utilities' market bidding strategies, it is highly unlikely that any party other than SPP or MISO have the raw data, modeling software access, and resources to conduct such an extensive analysis of market trends.
Do you think Mr. Laney's wrong?
I wouldn't say he's wrong. I don't have an opinion right now on this.
Thank you. No further questions.
Thank you. Are there questions from the commission for Ms. Wildheimer? Mr. Chairman?
Thank you. In your rebuttal, you state that you didn't find enough evidence was presented to warrant changing the current cost-sharing mechanism to 8515. What type of evidence should the commission be looking for to make that determination?
As far as staff goes with imprudence, it really could be anything that affects the fuel adjustment clause, any costs going into that. As I mentioned, in earlier cases, it dealt with off-system sales revenue. It could deal with natural gas cost hedging. I can't predict what could happen in the future, but it would certainly be, and again, I know I'm repeating myself, it would have to be looking at a pattern of any number of imprudences with any of these fuel cost areas or the accounts that go through the fuel adjustment clause and the numbers that are recovered.
And nothing that you looked at indicated to you that we should move from 95.5 to 85.15?
I've seen no evidence of imprudency that would cause me to think we need to look at the 95.5 differently.
Okay, thank you.
Commissioner Keating? Commissioner Rube?
Morning.
Good morning.
I wanted to follow up on a couple of interactions you had with the Office of Public Counsel. You stated that staff would not recommend any changes to the FAC cost sharing unless they saw a pattern of imprudence in their cost in controlling their costs. You also stated that in the past, staff had recommended an 85-15 in previous cases for this utility and other utilities maybe. Then you also stated that in 2010 and 2012, dear memory, that was the last time that staff had brought an imprudence charge against the company. Did I kind of write my notes down correctly? Okay. In those 2010 and 2012 cases where the staff felt that the company acted imprudently, did you correspondingly suggest an 85-15 cost sharing because of those?
I can't say for sure. I don't think so.
Okay. So if that's the case, even if you did find imprudence, you did not recommend a change to the cost sharing?
I'm not sure what staff did at that time. I do know the two cases. My understanding was it was the same issue, but possibly carryover because it dealt with specific contracts.
Okay.
So that may have had a factor in what staff recommended at the time.
Okay. You also stated that the FAC is a sharing mechanism that gives the company an incentive if they properly manage their fuel purchasing. Were you characterizing that as the company is being given this mechanism because they properly manage their fuel purchasing, and they are given the FAC cost sharing a 95-15 or 95-5?
My understanding was it's an incentive for them to appropriately manage their fuel and purchase power costs.
So it's an incentive for them to appropriately manage their cost. It's not an incentive so they will properly manage their cost. Is it an incentive to entice behavior, or is it you've shown prudence in your decisions, so we're going to allow you this because you've shown prudence in managing your cost? I guess, is it given proactively or reactively based off the company's history?
I mean, it depends on the periods. Certainly, it's both, I believe.
Okay. So staff then would believe that allowing a company to have a 95-5 cost sharing can be viewed as a benefit to the company for past prudent decisions in managing their costs.
Yes.
Okay, great. That's all I have. Thank you.
Commissioner Coleman? Commissioner Holzman, any questions? Is there further cross-examination based on commission questions from Ameren?
None.
Consumers Council?
No, Your Honor.
Public counsel?
None, thank you.
Is there redirect? Staff?
Could you please turn to the Ameren's 7th Prudence Review Report?
Yes.
Turning to page 31, Mr. Hall was asking you to describe some documents in section 4.
Yes.
I'm not going to belabor this point, but letter A is responses to some data requests. I'm sure this has been a while ago, you don't recall what's in the data request, but is it safe to characterize data requests as often containing several pages, numerous documents? It's just not a single sheet of paper?
Correct, many times.
And letter B is Ameren's work papers. What are Ameren's work papers typically?
These are, it could be any number of Excel worksheets to support the numbers they provided us.
And often these workbooks will have multiple tabs in them.
Correct.
Is it fair to characterize work papers as often being voluminous?
Yes.
And you also looked at Ameren's monthly reports. What kind of reports are these?
Again, they're Excel worksheets with several tabs of information, much information regarding the fuel costs, just a wide variety of information.
And you also reviewed Ameren's general ledgers and journals?
Correct.
It's fair to say that those are pretty long,
Yes.
too?
Yes.
If you could please turn to page 37, going over to page 38. Letter A are responses to staff data requests, and you already stated that those can often be very long. It's just not necessarily a single page of paper.
Yes.
And the work papers you examined, that's letter B, those can often be voluminous and...
Correct.
Okay. The general ledgers are often voluminous also.
Correct.
And letter D is MISO schedules and MISO tariff module C and F. Could you describe MISO schedules?
Based on what from this website, it has to do with explaining the elements that I used, the elements that I reviewed in this OSSR section. But beyond that, I can't tell you what is specifically stated in Module C and Module F. I don't know.
Okay. And the FERC definitions, that speaks for itself pretty much. That's
Correct.
Something you pulled off the website. And Mr. Hall also asked you to look at the rebuttal testimony of Sean Lange.
Yes.
And if you could turn to page 4, please. He pulled out a sentence towards the top of the page about it's unlikely that any other party other than SPP or MISO have the raw data, modeling software access, and resources. Do you know what he's referring to there, Mr. Lange? If you could skip up a couple sentences, you might see that.
I know basically what it's dealing with, but I can't answer any self-scheduling questions. So no, I'm not aware of that.
Does self-scheduling have anything to do with the FAC?
It's involved in the FAC prudence reviews.
But when you review data from Ameren, do you have any problem getting data or materials or anything from Ameren that you need?
Typically, no.
They provide everything that you need to do your prudence reviews?
Correct.
Mr. Leahy's testimony in response to the FAC prudence review.
Okay. Was Mr. Lange's testimony in response to the FAC review in this case?
Not that I'm aware of, no.
Do you know what he was responding to?
I thought he was responding to the self-commit issue in and of itself.
Okay. You stated that if you found that Ameren was not managing its costs correctly, that you would bring it to the commission's review, right?
Correct.
Does OPC have that same opportunity to review Ameren's costs?
I believe so, yes.
So OPC gets all the same information that you do through data requests, and they're available to depose witnesses just like staff can?
That's my understanding, yes.
Are you aware of whether OPC does any analysis?
I can't answer as to what they do. I don't know.
To the best of your knowledge, has OPC ever found any imprudence?
I think in the past there have been cases where, well, yes, they have found imprudence, and sometimes they have agreed with staff's position of finding imprudence.
But have they found any imprudence on their own?
I don't know offhand. I don't know.
Did you find imprudence recently in some MIA reviews?
Yes.
And which reviews were those?
We found recently in the Ameren MIA prudence review.
And what was your recommendation?
I can only speak to my issue, and that involved throughput disincentive. I know other staff cited imprudence with some of the costs that they were recovering or trying to recover through that mechanism.
And what was your suggestion? I'm sorry, I just didn't hear it.
I had suggested a disallowance regarding throughput disincentive.
Okay. And do you know how that was resolved?
The parties agreed to a black box settlement.
Okay. Was there requested, or did your group find disallowance in a KCP and LFAC review?
Yes, in the past.
Do you remember how long ago that was?
I know when the hearing was. I can't tell you offhand what the period that was covered in it.
Do you recall what the imprudence was, or the found imprudence?
What was brought to hearing was the renewable energy credits. Staff proposed a disallowance because it appeared the company had not taken any action to attempt to generate revenue from unused RECs that were not used for res compliance.
And how was that resolved?
There was a hearing, but I think it's been, I think it's still in process after the commission made the decision.
Okay. Do you have anything else to mention regarding the last FAC filings of Ameren?
There's been talk of over-recovery and under-recovery, and for the last 8 FAR filings since the last general rate case, it has resulted in a total over-recovery in which 95% of that over-recovery was refunded back to the customers.
Okay, thank you.
Thank you. You may step down, Ms. Oh, I'm sorry. Commissioner Roop, you had a question?
This may be not your area of expertise, but the $32 million rate reduction that's in the STIP, what does that equate to on an average customer's bill on a percentage? Do you know?
I'm sorry, I don't know that.
Okay. Somebody could get me that. That'd be great, because I didn't see it broken out that way. Thank you.
The stipulation is noticed up for agenda this afternoon for discussion, and if parties could find that number for Commissioner Roop.
I think we can do it by probably some pretty basic algebra, because we know what the decrease was from the 0.7 million that we had asked for. So somebody will do the algebra and try to get you the number by noon.
Okay, thank you.
I don't think it's in the record, but I think the algebra will tell us.
All right, thank you. Ms. Wildhaber, you may step down. Thank you. I think that was our only staff witness, so public counsel.
Public counsel calls Lena Mantle to the stand.
Do you solemnly swear or affirm the testimony you're about to give will be the truth?
Yes.
Thank you. Can go ahead, Mr. Hall.
Oh, Ms. Mantle, good morning.
Good morning.
We're still in morning. Ms. Mantle, would you please state your name and spell it for the court reporter?
My name is Lena M. Mantle. Lena is Lena. Mantle, Mantle.
And by whom are you employed and in what capacity?
I'm employed by the Office of Public Counsel. My title is Senior Analyst.
And on whose behalf are you testifying today?
I'm testifying on behalf of the Office of Public Counsel.
Did you cause to be filed in this case direct rebuttal and surrebuttal testimony under your name?
Yes, I did.
And that is the direct rebuttal and surrebuttal testimony that is marked for Exhibit 200, 201, and 202. Am I correct?
Yes, and I left my copies on your desk.
Your Honor, if I may approach my witness to get her copies.
Go ahead.
Thank you.
If I ask the same questions that are included in that testimony, would your answers be the same or substantially similar?
I do have one correction in my direct testimony.
Where is that?
On page 3, line 19, the sentence that starts with "it is the comparison of the sum of these two pieces." I would like to strike the words "the comparison of." The sentence should read, "It is the sum of these two pieces of normalized revenue requirement that is compared to the normalized revenue requirement in the test year to determine if there needs to be an increase or decrease in rates."
Other than that correction, do you have any other corrections you need to make to your testimony?
No, I do not.
Are the answers included in these testimonies true and accurate as to your understanding and belief?
Yes, they are.
Your Honor, at this time, I move for admission the Exhibits 200, 201, and 202.
Would there be any objection to Exhibit 200 and it's 201 plus the confidential version, correct?
Yes, I should have been clearer. Exhibit 201, both public and confidential, and 202, which is, there's no confidential version.
All right, thank you. So 200, 201, both public and confidential, and 202. Any objection?
None.
Seeing none, then I will admit those exhibits.
And I tender the witness for cross.
Is there any cross-examination by Consumers Counsel?
Yes, Your Honor. Good morning, Ms. Mantle.
Good morning.
Whether the commission adopts a 95-5 or an 85-15 sharing percentage in this case, we don't know whether or not the dollar impact will be negative or positive for consumers, do we? Over the next few years.
We don't know the total direction. It will be negative or positive,
Right.
but it could very well be both over the next few years.
But can we not say with certainty that it will have an impact on the volatility that consumers have to absorb?
It will have an impact on the volatility of their bills that they see, because they will be recovering or being returned varying amounts every 4 months. It changes.
Right. And regardless of what degree of care or prudence the utility engages in, this decision will have an impact on how radically the rates may be able to change in between rate cases. Is that fair?
In as much as the FAC charge, yes, there's several other surcharges now that the utilities can offer.
Why do you think it's fair that consumers should have to bear even 85% of the changes of one cost in between rate cases?
Personally, I don't think the customer should bear any of the cost. I think it should be back like it was. But this commission has determined that an FAC should be, the companies, the utilities should be allowed to collect some of those costs in between rate cases. I believe 5% is very little skin in the game, typically less than about 0.5%. Over the time period of Ameren's FAC, Ameren has actually not absorbed anywhere close to 5% of these costs. They've only absorbed 0.67% of their fuel cost, and the ratepayers have had to absorb the other 99.6 or 0.4% of the cost. The customers have one resource. They can reduce their own usage, but they can't do anything about their neighbor. They can't do anything about the big industrial plant down the road that drives rate, that changes those rates too. There's nothing in particular that says they own that one thing that they control, how much they use, will really even impact the fuel cost at all.
So, assuming we didn't even have this rate case, that a rate reduction wasn't proposed, would the fuel adjustment clause be allowing during this current period an increase in customer bills, even though the overall revenue requirement of the company is going down?
I'm not for sure I understand your question.
Okay, let me just ask in general. Doesn't the fuel adjustment clause allow rates to go up for customers even when the overall cost of service to the utility is going in a downward direction?
Yes, and and really what the customer sees is the bill, and that's what it allows that bill to go up even if their other costs are going down in between rate cases, because it's just looking at, it's not just one cost, there's several in the FAC, but a limited view, and that gets to be passed through to the customers, 95% of it.
And what direction did fuel costs change in the most recent fuel adjustment clause change?
They went down.
Okay. In your mind, is the sharing mechanism designed to be a reward or a punishment for prudent or imprudent behavior?
It should not be seen as a punishment. It should be a reward for cost-effective behavior that continually strives to improve and to get better and to be more efficient. That while you may reach the pinnacle of efficiency today, tomorrow it will be different. And to have some, what's been referred to as skin in the game for the utility, helps them to keep looking towards that.
But should that incentive be viewed as a punishment or a reward, or just as good policy that promotes the most cost-effective behavior?
It should be seen as good policy. So, and now, of course, whether it's a reward or a stick or a carrot depends on which end that you're on. But it's just good common sense that if you allow a reward, allow the utility to have more money if they save money, or not be able to recover as much if they don't, that's common sense that people will act in their best interest.
So you've been doing this a long time. You've been watching Ameren's activities for, I would say, several decades. Is that fair?
That is fair.
And over the time, and you've monitored this utility in times when they had no fuel adjustment clause, and then when they've had a fuel adjustment clause. Is that right?
That is correct.
Have you noticed any change in the way that the fuel costs are managed with and without the fuel adjustment clause in general?
I know now it is much more complex than it was before. I mean, and it doesn't have anything to do with the fuel adjustment clause. It's the market, the MISO market. It's a lot more complex. The decisions are made based on different things now than they were prior. I also have seen in rate cases the determination of the fuel cost before there was an FAC. That was a highly contested issue. And now it is typically, it's not a contested issue anymore.
Okay. And during the times when there was a fuel adjustment clause, then there wasn't, and the back and forth, did you see the Public Service Commission make any changes to the return on equity for Union Electric, Ameren, Missouri, as a result of the change in this mechanism?
There's been a change in the ROE, but that is not my area of expertise. My general understanding is there's a lot that goes into that. And I have not seen that the FAC drives that number. And it used to be high because the markets were different than they are now. Even 9.5 is high now. But it was 12 to 14% previously.
Allowing this monopoly utility to transfer 95% of one of its biggest expenses, how significant is that change on the utility's business risk?
I'm going to object. She just said it's not her area of expertise.
I'm not asking about return on equity or cost of capital specifically. I'm asking about business risk.
And business risk underlies what is allowed for the return on equity.
Okay. Can I get that on the record?
I'll sustain the objection.
Okay, that's all I have then.
Is there cross-examination from staff?
None.
Ameren?
Good morning.
Good
I don't have
morning.
any questions. Have a good day.
Are there questions for Ms. Mantle from the commission? Mr. Chairman?
Yes, thank you. Are you asserting in any way that the company could do more or isn't doing enough to keep its costs as low as possible in related to fuel?
I'm asserting that a certain amount of pressure needs to be continually on a utility, whether it's Ameren, UE, Evergy, Empire. A certain amount of pressure needs to stay on them so that they are efficient. Complacency can come and set in on the utility that's doing a good job. And I'm not saying Ameren isn't, but today's market is different than tomorrow's market, and it's different than yesterday's market. And the decisions that have to be made, there's what is good practice today is likely not necessarily going to be a good practice next year. So to say that today they're doing the best and therefore they don't need anything to keep them efficient is putting blinders on, because the FAC looks at cost going on a forward basis, unlike a lot of our work here at the commission where we look at the historical. This is setting things for a progression, what's going to happen, after you make this determination. So,
But can you predict the future?
no, I wouldn't be here if I could predict the future.
So then you can in no reasonably way say that 95%, the 95.5 is not an appropriate amount moving forward?
I don't believe anybody in this case has said 95.5 is appropriate because of anything other than that's the way that it's always been. Nobody has said this 95.5 is right because of these measures. The same way that I've been asked to say, well, what makes it right for 85.15?
Well, have you shown in any way that 95.5 is not right?
There is no way to know, because that is the only thing that has ever been done by this commission.
Has there ever been a prudence case brought on this issue?
On the issue of the appropriate sharing mechanism?
On the fuel adjustment clause?
We have just in the past, the Office of Public Counsel has in just the past 3 years brought up several issues, not with Ameren, but with Evergy and Empire. And there have been some things that we have caught in FAC rate change cases for Ameren that did not rise to a prudence audit, but different things that have been done that were corrected along the way. So yes, we have our office has looked at prudency, and we have placed before you instances where we felt the utilities were acting in an imprudent manner.
But in this particular case, with the evidence before us, no one is alleging that this has been imprudent.
No, and
this company has acted imprudently.
No, we haven't.
And that 95.5 has not worked for this company in this case.
I believe they could be imprudent if they moved to 85.15. I think you're trying to tie two different things together that don't necessarily tie together.
Well, I guess I'm just trying to understand the rationale of we have no reason to believe, or you have presented no reason to believe that this has been an inappropriate ratio thus far, but you think it might be in the future, but we can't predict the future. So you can't say it's not. I'm just trying to, it just seems like a muddled logical mess to me.
It is a muddled logical mess. And I will say that, in this time of decreasing fuel cost, it kind of befuddles me that the utilities don't want to move to an 85.15 if they truly believe that their net base energy cost is a good one.
But you
then they will make money. They will make more profit off of our 85.15 versus their 95.5.
Did you sign off on the net base energy cost?
Yes, we did.
So you also believe it's appropriate?
We looked at all factors in the stipulation and agreement, in addition, including the fact that our customers would get a rate decrease sooner. So it is one of the things that we looked at in determining whether or not we would sign the stipulation and agreement.
But you did sign off on that?
Yes, OPC did.
Okay, thank you.
Commissioner King? Commissioner Roop?
Good morning.
Good morning.
Following up on your conversation with the chairman there, you stated that the current FACs at 95.5 sharing, the logic behind it is a muddled mess. Is that because the reason we have a 95.5 was born out of a negotiation between commissioners to try to get 3 votes, and so they arbitrarily picked the numbers to try to, so that they could get to a majority?
That would be the genesis of the muddled mess. There was nothing to, no nothing to back that 95.5 up. I will say that Ameren, Missouri, when they got their first FAC and then filed another case right on the heels of that, and that commission asked the parties to propose something, after we filed direct testimony, after we'd filed other testimony, that commission came back and said, parties, give us something other than 95.5. And at that point, I came back in that case and said, we haven't had enough experience with 95.5. Ameren hadn't even filed its first rate change under that new FAC. So there's been commissions in the past that have questioned the 95.5. It's been a while since that. So it's you saw my name on the list of all the different times that I believe this commission deserves it placed in front of it the ability to change if it so sees. And so the fact that it's been 95.5 doesn't mean it should be that for forever. And I
So 95.5 was arbitrarily picked, and it became the default status quo. Instead of changing the status quo, it tends to be difficult, especially after time goes by.
That is correct.
And you stated that very shortly after this was established, the commission at that time had interest of possibly changing 95.5 or was wanting to do something different. But the relative fact that they had just started it recently, the argument was, well, there's not enough. You're going to mess up our data because we just started this. We need data and stuff. We can't change it right now because we don't even know how this is working yet.
We haven't even had a chance. I think there had been one rate change. And that kind of says, well, then why now? What shouldn't I have more data? The fact is, I've got 1 point. I don't know what would be different if you changed it. We've got 1 point, and everybody assumes that that's the optimal point.
And we assume it's the optimal point because it's the status quo.
Yes.
And that's just what we've always done.
Yes.
And now you're in a position of having to defend an 85-15, a 75-25, a 90-10, or whatever, and prove that it is the right thing to do, but we're not proving that 95.5 is the right thing to do.
That is correct.
Okay. Going back to your rebuttal testimony, and you don't have to look it up, I'll just kind of summarize it and you can tell me what we were talking about. You were responding to Sierra Club, I think. It's on page 17 of your rebuttal testimony if you want to look it up. Talking about coal plants as must run in the MISO market, where you were asked on line 11, what's the impact on customers when Ameren Missouri designates these units as must run, despite it not being economic for them to run? And then you respond, because Ameren Missouri has an FAC, where only 5% of the increased cost is absorbed by Ameren Missouri. It only sees the impact of 5% of the extra cost. The other 95% of the uneconomic decisions, sorry, I'm talking really fast, paid for by the Ameren Missouri ratepayers through its FAC. And the next question on line 17 was, in your opinion, would Ameren Missouri be designated these plants as must run if it did not have an FAC? To which the answer was, I do not believe that Ameren Missouri would be dispatching these units in this manner if it did not have an FAC. Did I summarize that correctly? Or read it?
You read that correctly,
excellent,
yes.
Very good. So my question to you is, would Ameren Missouri be dispatching these units in this manner under your sharing percentage proposal of 85-15?
I don't know. A very honest answer. 15% still isn't very much. The Sierra Club, I think the total was it was less than $1 million. So we're talking about even 15% of that is not a large number. But I do think it would be more likely with 15% than it would be 5%.
So do you view this FAC sharing percentage and the self-committing issue as intertwined?
I believe that, yes, I do, because when Ameren sees very little impact for the self-committing, when it knows it's going to recover those costs, because as it's already been said, the volume of data to do a prudence audit over every one of these decisions. Ameren doesn't even keep that data for anybody to look at it to know whether or not it was prudent. I'm not saying, I realize that's a huge volume of data, but just, and I got sidetracked there, but there's a lot of decisions and data is not kept for prudence audit. I don't think that it's thrown away so that a prudence audit can't be done. Please don't hear me say that. I don't think Ameren is intentionally saying, well, they're going to do a prudence audit of that, so I'll throw it away. But there's a lot of decisions to be made, and when they're going to receive most of their payment, 95% of that difference anyway, then I think there's very little incentive for them to make economic decisions.
Thank you.
Commissioner Holzman, Mr. Chairman, you had an additional question?
Thank you. Yeah, just a quick follow-up. And I think you kind of touched on it on the end of your conversation with Commissioner Root, but does a 5% cost share offer any incentive to Ameren to control costs?
In my opinion, it does not. It's not 5%. It's 5% of a incremental difference. So we're talking less than 1% of their total fuel cost.
So you don't believe it offers any incentive?
No, I do not.
It could be 5% or it could be 0.
That's right.
And this commission could find it to be 0.
And it would probably have about the same incentive, yes.
Okay, thank you.
All right, is there cross-examination based on commission questions from Consumer Counsel?
No, Your Honor.
Staff?
No.
Ameren?
Yes. Thank you. So, Ms. Mantle, what year did, let me start by Commissioner Rube asked you some questions talking about the genesis of the 95.5 sharing. You remember those questions?
Yes.
Right. And I think you talked about the FAC for Ameren, Missouri being granted in 2009. Is that correct?
It was in their 2008 case. 2009.
So it took effect probably in 2009?
March 2009, I believe.
Okay. And Ameren, Missouri has certainly had the FAC at issue in every rate case filing since then, correct?
Yes.
And you saw the attachment to Andrew Myers, the exhibit to Andrew Myers' rebuttal testimony that listed all the different cases and which parties had presented alternatives to the 95.5 sharing, correct?
It listed all but 3 cases. I'm just assuming those got overlooked, and it also included a case where Ameren's first case in which you asked for an FAC where you did not get them. So it wasn't just, but it is a list of all the rate cases, yes.
Okay, fair enough. So when Ameren, Missouri filed case ER-2019-0335, would you have still been on staff?
Yes, I was.
Okay. And did you suggest a different sharing percentage at that time?
I don't mean to interrupt, but if it will aid in questioning, we have copies of the schedule that Ms. Tatro is referring to, if the witness would like to review that.
Which case were you referring to, Ms. Tatro?
ER-2011-0028.
So that would have been 2 cases removed from the case where you received your FAC? And
were you the witness for staff on the FAC sharing percentage in that case?
No.
Okay. Who was?
Matt Barnes.
Okay. And did Mr. Barnes recommend a different FAC sharing percentage?
He recommended 85-15.
Okay. May I approach?
Yes, go ahead.
But I only have to do this once. I'm going to give you 2 of them.
Can you show that to her attorney?
Oh, yeah. This is the section on the FAC in the report and order.
From
11. And then we'll go through the 2012 as well.
Okay.
I'm just going to straight talk about the decision. And I don't have copies, so I didn't assume you'd be doing this.
Ms. Tatro, I do realize I was looking at the Empire case that Matt Barnes provided testimony in that case. You're talking about ER-2011-0028. I was the witness in that case, and it was 8515.
Okay. I'm going to hand you these two documents. And I apologize, it's my only copy. Yeah. We have taken notice of these, so they are in the record. But looking at the document from ER 2011-0028, it's the report and order from that rate case, correct?
Yes.
And I've only given you a portion of it, but could you turn to page, I believe it's page 86?
Okay, I'm there.
And there on the, about a third of the way down, it says decision, meaning commission decision. Well, first of all, it's in the FAC section, right, where if you look through there, it's talking about the sharing percentage, correct?
I'm not so sure this is an objection, but can I ask, before we go down this rabbit hole, for Ms. Tatro to identify which commissioner question this is responding or a reference to?
It was Commissioner Roop, which I previously stated. Is it about the FAC? Okay.
Yes, it's about the sharing mechanism.
And can you read for me the paragraph that's under the heading decision? I think it's conveniently highlighted for your convenience.
Staff stated reasons for experimenting with adjusting the sharing mechanism of Ameren, Missouri's fuel adjustment clause to implement an 85-15 split do not withstand scrutiny, imposing a significant financial burden on the company simply to experiment with an alternative sharing mechanism would be unfair to the company. The Commission finds that there is no reason to change the sharing percentages in the fuel adjustment clause under which Ameren, Missouri has operated for the past several years. The Commission will retain the current 95-5 sharing mechanism included in Ameren, Missouri's fuel adjustment clause.
So you'd agree with me, Ms. Mantle, that the Commission made an affirmative decision that it was going to retain the 95-5 rather than following your experimentation offer?
I would not, the Commission characterized as an experiment, and the Commission that was there at this time did come up with, that is the decision that they made.
Okay. Then the second document that I provided you is from ER 2012-0166. Is that correct?
Yes.
Again, that's another Ameren, Missouri rate case?
Yes.
And again, I provided you the section on the FAC. Is that correct?
That is what it seems, yes.
All right, and if you would turn to page 83.
Your Honor, I'm going to object. I'm not sure that I see the connection to the inquiry that Commissioner Roop had with this witness. If Ms. Tatro wants to recite various past orders on this issue, they've placed it in the record. They have the ability to cite it in their brief. I don't see the point of having the witness just read selected paragraphs that they like from previous orders into the record. It's already in the record.
I'm going to overrule your objection. I believe it relates to Commissioner Roop's question, and as long as it's not too onerous a provision of the statute or the report and order, go ahead.
Thank you. So, Ms. Mantle, are you on page 83?
Yes.
And again, there is a section labeled decision, and there's a paragraph. I did not conveniently highlight it for you this time. But can you read that to yourself, please?
Okay.
And again, it contains very similar language to the order that you read previously, the 2011 case, correct?
Actually, it looks like it was a cut and paste, except for 95.5 has percentages after it instead of just with no percentage. It is the very same paragraph.
Okay. And again, this paragraph says that the commission declines to experiment with adjusting the sharing mechanism of the FAC, correct?
Yes.
And were you the witness for staff in this case?
Yes.
Okay. And it also says that the commission makes, and in this paragraph, the commission makes an affirmative determination that there's no reason to change the sharing percentage in Ameren, Missouri's fuel adjustment clause, correct?
The commission did make a decision that there was no reason to change the sharing percentage in these cases.
Yeah, it's a specific finding, right?
It's under decision in their order.
And the language says the commission finds.
Yes, the commission finds there is no reason to change the sharing percentages in the fuel adjustment clause.
Thank you, Ms. Mantle. Nothing further.
Fine. Are there any redirect questions?
Just a couple, thank you. Ms. Mantle, Commissioner Sylvie asked you about your justification for proposing an 85-15 sharing versus the current 95-5 sharing. Do you recall that conversation?
Yes.
And do you recall, I believe it was in response to Commissioner Sylvie, but you also remarked that you would prefer a situation without any FAC in your personal preference, correct?
That is my personal preference, yes.
But that's not what you're asking for in this case, correct?
No, it is not. Our office decided that it would file testimony that did recommend that there be an FAC for Ameren, Missouri.
So then why are we asking to change the sharing mechanism versus strike the whole thing?
It has become established practice in the state of Missouri to have a fuel adjustment clause. What I have learned over these years with the fuel adjustment clause is that it is always changing, and it should always be allowed to be changed with changing circumstances. In every one of the cases, Ameren, Evergy, Empire, the utilities always ask for changes, modifications to their FAC. And this is a modification based off of what our office saw that the legislature had set what it believed was an appropriate incentive to result in action from the utility. We saw that as direction that we should also be asking for a change in the sharing percentage for the FAC.
When you just referenced modifications to the FAC, am I correct? You're talking about certain inputs that have been added to the FAC that weren't originally with the FAC?
There's been cost added, there's been cost changed, there's been changes to accumulation periods and recovery periods. There's been all types of changes in the rate cases before the commission, just as the statute envisioned when it said that they can only be changed or modified, continued, discontinued, or approved in a rate case. So it is an evolving creature, the FAC is.
Chairman Sylvie also asked you about our office's agreement to the net-based energy costs. You reviewed the net-based energy cost numbers that were proposed by staff and the company for this case, correct?
Yes, I have.
And in your work from being on both staff and OPC, you've reviewed net-based energy cost filings before, correct?
Yes.
In your experience, has net base energy cost calculated in a rate case matched what the future is going forward?
It has not.
And that mismatch is not because of any active decision by a party. That's just how math works.
It's, the net base energy cost is based off historical and projected from production cost modeling. And it does not take into account all the things that happen just on a daily basis. So it will always be wrong, just as it was before there was an FAC. That fuel cost that was included in rates was always wrong.
Thank you, Ms. Mantle. No further questions.
All right, thank you, Ms. Mantle. You may step down. And I believe that concludes all of our witness testimony. Is there any other matters that the parties need to discuss on the record?
Commissioner Roop, would you like your figures before you leave? Appendix J to the corrected stipulation that was filed, I think, on March 2nd has the figures. It's about a 1.24% overall decrease. Residential's is 1.15%. Residential's will be about, typical residential customer would be about $1.15, $1.20 a month. You're welcome.
Thank you for that. Is there any other items that the parties need before we adjourn?
Real quick, not that I'm pushing for it immediately or anything, we have plenty of time, but transcripts, when do you expect them?
Right now, the transcripts are set to be returned to the commission on the third business day from today. So
Be available next week then.
So we'll get them in the record in EFS as soon as we can after we receive them and make sure everything's correct. And briefs are scheduled to be, initial briefs are scheduled to be filed March 30th, reply briefs April 7th. We haven't ordered this in a long time, but I will invite you all to file proposed findings of fact and conclusions of law if you'd like. You're not required to by any means, but
Okay.
they will not be rejected. Anything else? I do appreciate the amount of work that went into the stipulations and agreements and limiting this hearing to a few hours. So thank you all for your hard work on that. And the stipulation is scheduled to be discussed in agenda in a few minutes. So with that, we can adjourn and go off the record. Thank you.